Good afternoon. Welcome to the American Enterprise Institute. I'm Tom Miller, Chief Entertainment Critic for Health Policy, which rarely fails either to amuse or appall us. Today's conference is co-sponsored by our silent partners at the Federalist Society, whose secretary may disavow all knowledge if this tape is captured. Our mission impossible today is to make a little more sense out of the law of severability, which tends to pop up from time to time when Congress makes a mistake in the laws it writes and gets flagged by the courts for a violation. Our first panel will take a deeper dive into where we've been, where we are, and where we could or should go in the future in dealing with federal laws with constitutional or other legal problems. Severability essentially comes down to how much of a law, if any parts of it, can survive and function. If that happens, more on that in a moment. Some of our regular attendees and viewers may recall some earlier installments in this series of health law forums at AEI involving the ever-mutating Affordable Care Act, a renewable source of employment and commentary for lawyers and legal policy analysts. Last July, for example, we reviewed how the ACA bill that escaped Congress in March of 2010 launched a wave of litigation, regulatory revisions, and administrative workarounds. It was a little bit different from the simplified civic class process. And this cyclical process appears to be self-perpetuating, as the results of cases like NFIB v. Sebelius can produce a revised, if not completely rewritten law that can launch a new round of lawsuits. So as I've said before and mentioned in congressional testimony last week, and most likely will repeat again, welcome back to Groundhog Day, ACA litigation version. Or perhaps it's just an updated spin-off of the long line of Dick Wolf TV shows, ACA SVU. Making its debut in early 2018 was a case from Texas brought by 20 states, mostly Republican attorneys general, that claimed that after Congress had reduced the individual mandate tax to zero as of January 2019, the remaining individual mandate as a regulatory command had become unconstitutional, and here's your severability answer. The rest of the ACA in its entirety should be ruled unenforceable as well. That's sort of full-strength non-severability Texas style. There are other positions in that case, ranging from the Trump administration's lawyers setting for partial severability of several related regulatory provisions to excising just the individual mandate, and of course finding no constitutional and legal problems at all. More on that case during our second panel on severability as applied in Texas v. United States. Because I still need some continuing legal education credits and this area of law remains far from well understood or applied consistently, we'll start off with a longer range look at severability. Maybe not as far back as the old school biblical approach in splitting the difference or throwing out the baby with the bathwater. There was an objection on that artwork from the Department of Justice, but we've got it taken care of now. That fig leaf makes it a little bit better, if not for Obamacare. One of the goals of our first panel is to provide a better understanding of how our three branches of government might interact better in this area within the separation of powers framework that can get blurred when it comes to severability. All of this will be on the exam later, but here are some helpful course materials as part of your study guide. We begin on panel one with a pair of thoughtful scholarly critiques of severability law, its permutations and evasions, but also its better accomplishments. On occasion, our panelists won't exhaust every possible point of view, but they should get you to think more carefully about what courts do in this area and what might happen in the future. I'll introduce them separately. Our first speaker is John Harrison, who joined the University of Virginia School of Law faculty in 1993 as an associate professor of law after working in the Department of Justice for 10 years, including serving as the Deputy Attorney General, in the Office of Legal Counsel from 1990 to 1993. Clerk for Judge Robert Bork on the U.S. Court of Appeals for the D.C. Circuit. After graduating from UVA, he earned his law degree in 1980 at Yale, where he served as editor of the Yale Law Journal. Professor John Harrison. There or up here? Okay. Yep.
Thank you, Tom. It's good to be here. The great baseball theorist Bill James said, like Ronald Reagan, I believe in simplicity. I love complexity, but I believe in simplicity. What I'm going to try to do is talk about a somewhat complex topic, severability and inseverability, by building it up from what I hope are the relatively simpler building blocks that give rise to the phenomena and raise the questions that we'll be talking about. First thing I want to say is, what is the phenomenon that's under discussion here? And the genuinely interesting phenomenon, the one that came up in NFIB against Sebelius, that has now come up in the latest iteration of this problem, is inseverability. It is inseverability that is the issue. Inseverability arises when there is some statutory rule, body of statutory rules, that by itself or by themselves are constitutional, but nevertheless are found to be inoperative because something else, some application or some other statutory rule or set of statutory rules, is unconstitutional. How can that happen? The answer is that it can happen. Whether it happens is fundamentally determined by how Congress has legislated implicitly or explicitly about certain contingencies, but it can happen. And that's why there is the topic that we're talking about. Okay, the first thing I want to say by way of a simple building block is how the Constitution operates. The Constitution operates by creating a legal hierarchy in which it is at the top. And because it's at the top, and because of a few other basic assumptions of the American constitutional system, the Constitution provides criteria for the validity of non-constitutional laws. It determines whether they are actually legally operative or not. That was the premise of the Constitution itself. Lots of famous Supreme Court cases are about it. The point I want to make is the Constitution operates on the content of the law. The next point is the Constitution operates on the content of the law by saying what the law can't be. It says quite little about what the law is or has to be. Overwhelmingly, and here I'm going to be talking about Congress, similar questions, of course, can come up with respect to state law, but what we're mainly concerned with here is Congress. Overwhelmingly, what the law is up to Congress. What it's not is to a certain extent determined by the Constitution, but again, the Constitution, the constraints imposed by the Constitution are relatively generous. Notice that suggests, and I'm going to elaborate on this in a couple of moments, that suggests that because Congress says what the law is, and the Constitution says what it's not, what Congress has said is going to be the decisive question when it comes to the kind of thing that comes up under the rubric of severability or inseverability. Okay, so that's the first building block, the way the Constitution operates, constraining the subconstitutional law, but by and large not dictating the subconstitutional law. Next point, the levels at which the Constitution operates. The Constitution sometimes means that particular applications of a non-constitutional rule, say a statutory rule, are impermissible. The law can't be that in that particular circumstance, but that's just about those circumstances. For example, the Fourth Amendment says no unreasonable searches and seizures. If Congress authorizes a category of searches or seizures, say by federal law enforcement officers, says all of these are authorized and some of them are unreasonable, well, the rule that says they're authorized is overridden by the Constitution. They become unauthorized because they are unreasonable. People who engage in those searches can't rely on the defense of federal privilege, for example. But all the other authorizations left intact as far as the Constitution is concerned because the Constitution operates at the level of particular applications. Sometimes the Constitution operates at the level of the rule. And by saying that it operates at the level of the rule, I mean sometimes the Constitution means that a particular generalization that the legislature, say Congress, has used is impermissible. And as a consequence, that rule is invalid, inoperative, not to be followed, even though, and this is, as I say, the content of operating on the rule, even though some of the applications of that rule could have been constitutionally achieved pursuant to another rule. Classic example, the flag burning statute that Congress enacted in response to the first of the flag burning cases. Flag burning statute said this whole range of flag burning is illegal. Supreme Court said that is unconstitutional, as they say, on its face. The whole rule is unconstitutional. Nobody can be prosecuted under it, even though some instances of flag burning could permissibly be prosecuted under other laws. If somebody steals a flag and burns it, that's vandalism and can be prosecuted as vandalism. Can't be prosecuted under a rule specifically about flag burning. The fact that that's the Supreme Court's approach, and they interpret the First Amendment that way, and I think correctly, is a phenomenon about the First Amendment. There are circumstances in which the First Amendment operates on whole rules in that way. Interestingly, sometimes the Constitution operates on collections of rules. And this sort of thing comes up from time to time, and since this is an inside the Beltway crowd, you will know about some of these issues. Sometimes the combination of rule that's involved is a rule about the power of a federal officer and the means by which the federal officer can be removed or not removed. The number of important cases have been about that. The case about the Comptroller General and the Graham-Rudman-Hollings mechanism for deficit reduction was like that. And the interesting thing there is there are powers that can be given to officers provided they can be removed or not removed in certain ways. There are rules about removal that are permissible, that are fine for officers with certain powers, but there are some combinations of removal rule and power rule, even though either one of them in isolation might be fine in different circumstances, that are unconstitutional. That's what happened in Boucher against Sinar, the Graham-Rudman-Hollings case, where the Supreme Court said the combination of this particular power in the Comptroller General and Congress's power to remove the Comptroller General by statute was unconstitutional, even though there's nothing wrong with the Comptroller General having other powers and being subject to that form of removal. It was the combination of the two that was unconstitutional. I will say that sometimes ties the courts in knots, because that can produce difficulties when they think, but only one of those rules is actually before us. What are we supposed to do? My point is the Constitution can operate at these varying levels. Next thing, and as you're about to see, we're going to have a situation in which the Constitution and Congress are to some extent going to bump into one another. Congress operates at different levels. But probably the most fundamental level at which Congress operates is enactments. It passes laws. That's what Article 1, Section 7 provides for. The mechanism bill passes the Senate, passes the House, presented to the President vetoes or signs it, etc. That's the fundamental unit in which Congress operates. But it's not the only unit in which Congress operates. For legal purposes, probably the main unit, and these arise within those enactments I was talking about, are rules, generalizations. Congress says this is the rule in the following category of cases, the following thing is the answer. Very unusual for Congress to legislate in enormous detail and say, in this particular situation, here is the answer. Much more commonly, Congress operates at the level of rules. The Congress, of course, creates packages of rules. Some of them are those enactments that I was talking about. Not all of them, interestingly, are those enactments. For example, Congress legislates by enacting something called, I'll give an example, the Atomic Energy Act of 1954. Congress enacted the Atomic Energy Act of 1954 in 1954, and then subsequently has passed enactments that say the Atomic Energy Act of 1954 is hereby amended as follows. The result is a collection of particular enactments produce this construct that has nowhere once been enacted by Congress. It's the result of a series of enactments. Why does Congress do that? Congress does that in the pursuit, the extent to which Congress achieves this, of course, is one of the questions, in the pursuit of coherent policy. That is to say, Congress, for instance, wants to make sure that people never drop their pencils at AEI events and might require a wide range of rules that interact together in order to produce that desirable result. Notice the thing about the Act, to produce coherent policy, is to produce a combination of rules that will work together. Sometimes Congress does that, legislates in ways that interact with one another without even using the construct of an act, like the Atomic Energy Act. Rather, some provisions of different acts, of different enactments, will interact with one another, sometimes referring to one another, sometimes not referring to one another, in a way that reflects Congress's policy design. And that's what produces the problem of inseverability. Congress operates from the standpoint of policy through packages of rules, through combinations of rules that work together. That means that statutes are designed, and statutory rules are designed to operate together. Okay? Another building block. Congress works in these combinations. Now, one of the things that statutes have to do is deal with contingencies. What happens under the following circumstance? And in particular, statutes have to or ought to deal with contingencies that Congress did not focus on or focus on primarily in enacting its policies of rules. All sorts of things that can happen, and the courts need to know what to do in those contingencies. And one of the contingencies that can arise, actually the broader category of contingency that can arise that I'm thinking about, is the law might be something other than the law that was the primary predicate that Congress assumed when it put together the policy package of various rules, doing that in various ways. The law might be different from the one that Congress primarily assumed when it put the package together. The subpart of that we're specifically concerned about is because of the Constitution, the law that Congress, and here I'm going to personify Congress, and I don't want to put too much force on this way of thinking, that Congress thought was going to be is not the law. That is to say, the Constitution means that some of what Congress created is in fact going to be inoperative, it's going to be invalid because the legal hierarchy renders it invalid, and that means that the primary contingency for which Congress legislated is not going to be the one that actually arises. Something else has happened, and something else has happened to Congress's own laws, which is unusual. Because normally, why have rules? Rules deal with contingencies. Normally, one contingency Congress doesn't have to worry about is what's the federal law going to be? Because Congress can control the federal law most of the time, and so it can just put in place the assumption the law is this because it's what Congress says it is. Well, Congress doesn't have complete control over the federal law because the Constitution, to some extent, constrains what Congress can do. That's the situation in which Congress has put together, from the standpoint of policy, a package of rules, generalizations, that are designed to work together through one of these various mechanisms that Congress uses to get them to work together. Congress has put together a package, and the package confronts a contingency having to do with the content of federal law. And the contingency is not all of that federal law was constitutional. That's the issue that came up in NFIB against Sebelius, or was raised in NFIB against Sebelius. What if it turns out that part of this large package that Congress put together is inoperative because it's unconstitutional? And here's the crucial question that gives rise to the possibility of inseverability. Is it possible that some other components of that statutory package were implicitly predicated for policy reasons, because they interact with one another, were implicitly predicated on this particular rule being operative? The rule that was challenged, the individual mandate, as a policy matter, clearly other components of the Affordable Care Act were designed to interact with the individual mandate. Those interactions by themselves don't mean that any particular provision was predicated on the operative character of the other provision in the sense that it is implicit that it's inoperative. It's another step to say that. But that's the possibility that arises. Maybe because their policy interaction is so strong, one of them was implicitly predicated, its operation is predicated on the assumption that the other rule is in place. As I said, that was the question in Sebelius. Here is how the Supreme Court deals with that. Sometimes, on rare occasions, they can deal with it fairly easily, because sometimes Congress has explicitly dealt with the contingency of unconstitutionality and has said, if this package is in part unconstitutional, substitute this other package, an explicit fallback, as Professor Michael Dorf calls it. That's what happened in the Graham-Rudman-Hollings case. Congress had said, if what we have primarily designed here with the Comptroller General is unconstitutional, here's another way to proceed that is much less constitutionally problematic, and indeed people at the time thought was constitutional and still regarded as such. So sometimes Congress actually gives that fallback. Sometimes it doesn't. And the question is, okay, what are the courts supposed to do? These days, the Supreme Court's leading case on this, a case called Alaska Airlines against Brock. And Alaska Airlines against Brock is worth thinking about because it involved a plausible claim. The Supreme Court ultimately rejected it, but a plausible claim that one statutory rule was in fact implicitly predicated on another one being operative. The two statutory rules were regulatory authority granted to the Secretary of Transportation and a so-called legislative veto that Congress had imposed by statute, meaning one house of Congress could undo the regulation that the Secretary had adopted. Congress, a few years before Alaska Airlines in the Chadha case, had said legislative vetoes are unconstitutional. Well, it's entirely possible that supporters of regulation were prepared to give that authority to the agency only if they retained the string of the legislative veto. So there was a reasonable argument that the legislative authority was predicated, it was indeed part of a policy package, that much is clear, was predicated on the availability of the legislative veto. The Supreme Court had decided that the legislative veto was unconstitutional and inoperative, and here's an important thing about inseverability being the problem, and the regulated party, Alaska Airlines, said the Secretary does not have this authority, not because the authority was said to be unconstitutional, but because it was part of a policy package, another part of which, the legislative veto, was unconstitutional, and, said Alaska Airlines, Congress had in fact made one dependent on the other. Again, not directly a constitutional argument, a party not affected, no legislative veto had been used, a party not affected by the legislative veto, affected by the grant of regulatory authority to the Secretary, posing a classic problem of inseverability. Supreme Court said they are severable. Congress would have enacted the regulatory authority even without, putting it in counterfactual terms as is often done, even without the legislative veto. And the court announced or repeated a standard formulation, and I'll just quote this. Unless it is evident, because this is one of those, in Alaska Airlines, this is Alaska Airlines quoting another case, quoting another case. This is the court has said this any number of times by now. Unless it is evident that the legislature would not have enacted those provisions which are within its powers, in Alaska Airlines, that's the regulation, independently of that which is not, in Alaska Airlines, that's the legislative veto, the invalid part may be dropped if what is left is fully operative as a law. And in previous cases, subsequent cases, the court has put that in terms of, has said, this is an inquiry into, and here fill in the blank about how you describe what the courts are looking for when they're trying to identify the content of statutory law. Is it legislative intent? Is it text meaning? That depends on other debates. The important thing is that question is inseverability triggered, even though the legislative provision that the court is concerned with, in Alaska Airlines, the perfectly constitutional regulation, is that triggered even though it is constitutional? And the answer is that it may be if there is a policy package and I stress these are two different questions, and Congress has implicitly, because these cases aren't Boucher against Sinar type cases where Congress has said something, and Congress has implicitly made the operation of the constitutional piece predicated on the piece that turns out to be unconstitutional. That's how the problem arises. The building blocks of how the American constitutional system, the way Congress operates, generate these problems. And what I just said, the basics about how the Supreme Court approaches it. There are a couple of issues in the court's doctrine. I will just flag one that I think is interesting and then talk for the last couple of minutes of my part here about the other one. The first one is, and goes back to what I was saying a moment ago, what is the object that courts are looking for when they, as we say, interpret statutes? And as you know, for a few decades now, there's been a renewed debate about that among judges, among scholars, among justices, between basically the camps of intent, meaning some subjective mental state of actual legislators, and text, meaning something more objective, meaning in the statute. And one question that arises here arises because in the cases specifically about severability and inseverability, the Supreme Court routinely describes the question. It's an inquiry into what Congress has implicitly provided for. And they routinely describe it in terms of the intent of Congress. And that then raises a question, is the court actually committing itself in the area of severability to a subjectivist kind of inquiry? Or is it just, well, that's how the justice who wrote that opinion happens to talk about inquiries into statutory content? I think that's an open question. I think it poses a tricky one for the lower courts, because sometimes the Supreme Court's doctrine does include some methodological principle like that. Normally, interestingly, it doesn't. And the lower court judges follow their own views about how to understand statutory content. Is it subjective? Is it objective? But if the court says it's subjective here, well, it's subjective there. Whether the court has done that, I think, is not clear, but one might say that it has. The other issue, and this has come up a couple of times in the last few decades, came up in Sebelius, and I think is presented in the Texas case, is the question of severability properly understood? The way I described it, presenting what I think is the classical approach, properly understood as a question of the content of the law, or is it properly understood as a matter of judicial remedies? The other way of understanding it is to say, when a court confronts an unconstitutional statutory provision, what it does is make it invalid. As the courts often say, we invalidate this component. Well, if that's what's going on, if a court is applying the remedy of invalidity, of, as it were, severing the statute, not finding what the law is, but making it invalid because the Constitution says to make it invalid. Notice that's how the law of remedies routinely operates. The law of remedies says, the primary law would say, here is what a nuisance is. The law of remedies says, and the court can enjoin a nuisance. An injunction changes the obligations of the parties. An injunction creates a new obligation that hadn't existed before. A party subject to an injunction now can't do something that previously was either lawful or would give rise only to damages. With the injunction in effect, the party faces contempt of court if the party violates the injunction. That's a change in the content of the obligations of parties brought about by a court in carrying out the law of remedies. Notice the two steps. First, the primary law, is this a nuisance? Then the possible change in the law through the law of remedies. If you think that the questions of severability and unconstitutionality generally raise the law of remedies in the sense of courts changing the content of the law, then a natural question is, well, what remedy should the court apply? How much of the law should it make invalid? That's another way to understand severability. One important consequence of that, and this came up in the Sebelius NFIB against Sebelius litigation, has to do with another one of these fairly technical doctrines, the idea of standing. Standing says that a party can get relief, like an injunction against the enforcement of a statute, only with respect to rules that apply to the party. And in NFIB against Sebelius, the parties who challenged the individual mandate hadn't shown that any other part of the ACA applied to them, but they said, court, say the whole thing's invalid, if you like, invalidate it. As the remedy, you will remedy the problem we actually have, which is with the individual mandate, and we want you to apply the broader remedy of invalidating the entire act. Well, if invalidation is a remedy and the court must decide how much of a remedy to give, maybe that's okay. If invalidity is a phenomenon of the primary law, and parties can complain about only those parts of the primary law that apply to them, then a party not subject to all these other parts of the ACA that may have been inseverable did not have any grounds to ask a court to say anything about any of those other parts of the law. The joint dissenters in Sebelius actually addressed this question and took, and this is the last thing I'll say, and took what I think, or the next to last thing, took what I think is the wrong approach. They said this is a question of severability, and hence we can decide whether to invalidate the entire statute. I think the fundamental predicate of the American constitutional system is that invalidity is produced by the Constitution. It is not produced by the courts. They do not, in fact, dispose of this remedy to make laws unconstitutional. Two little pieces of evidence for that. Congress enacted the Illegal Tender Act in the 1860s. Supreme Court said it was unconstitutional. A couple years later, Supreme Court overruled the legal tender cases, said it was constitutional. The Legal Tender Act went back into effect, practically speaking, without having been reenacted by Congress. How did that happen? Because the content of the law had not changed. The Supreme Court had simply said something about the content of the law. Second, we always focus on the Supreme Court of the United States in talking about this sort of thing. And the Supreme Court of the United States can do something that is functionally similar to changing the content of the law nationwide. Courts of appeals can't. Can a court of appeals actually make a law invalid? Well, only within its own appellate jurisdiction. If the Ninth Circuit says a statute is invalid, it's not invalid here in the D.C. Circuit. Seems to me that fact shows that what's really going on here is courts are interpreting the substantive primary law, not changing the law. The last thing I'll say to connect this to the Texas case is if I'm reading the Texas case correctly, this question, whether severance, as it said, is a remedy, comes up in the Texas case, I think, as it came up in NFIB against Sebelius, because from what I can tell, the parties there, too, have shown only that they are subject to the individual mandate, not that they are actually subject to all those other parts that they want the court to say is inseverable. If that's right, if I'm reading the case correctly, that means that the courts, I think, should not address that issue because of the combination of standing and the way I think severability operates. Whether severability operates like that, though, is a matter of some current controversy. Thanks.
Very much. Your description of legislative packages when I was thinking about the ACA made me think of a package that wasn't fully assembled but was shipped nevertheless in a bit of a hurry, apparently either Amazon Prime, if not UPS, and then we had to figure out what was inside of it on Christmas morning or shortly thereafter. Our next speaker, I'll just introduce him from here, and David will speak at the podium, I guess. David Gans is director of the Human Rights, Civil Rights, and Citizenship Program at the Constitutional Accountability Center. He's a co-author in 2014 of Religious Liberties for Corporations, another case involving Hobby Lobby, the Affordable Care Act, and the Constitution. He joined the center after serving as program director of Cardozo School of Law's Florsheim Center for Constitutional Democracy, and he was an attorney with the Brennan Center for Justice at NYU's School of Law. Previously, he was an acting assistant professor at NYU and also served as a law clerk for the Honorable Rosemary Barkett on the U.S. Court of Appeals for the 11th Circuit. David is also a graduate of Yale Law School. We're just overloaded with Yaleys today. Sorry, Harvard, you didn't make the cut today. We've got some more on the next panel. And he also served as an editor on the Yale Law Review. David Gans.
Thanks so much. So I want to just say thanks so much for having me and convening this to talk about severability, which is an incredibly important topic that is, I think, often misunderstood. And what this case sort of highlights, this is a doctrine that is crucial, that comes up time and again in loads and loads of really important constitutional cases. And usually we're really interested in sort of the big constitutional question to which severability is appended. So I applaud kind of this focus. And I think partially because of severability being sort of an adjunct to a dispute about sort of the extent to which the Constitution limits federal or state power, it's misunderstood, ignored. Sometimes major Supreme Court precedents that are taken as precedents on severability are cases where the Supreme Court never said a thing about severability, but we now sort of consider them as part of the severability canon, and the Supreme Court cites them as severability precedents. And this, among many features, kind of produces a state in which we have a severability law that is somewhat problematic. I sort of want to sort of pick up where Professor Harrison left us, which is sort of this question of what exactly is a severability, Is it remedial? Is there something else? So the sort of black letter law of severability sort of reduces to maybe three kind of fundamental points. So one, what is it? It's talked about as statutory construction, which I find sort of problematic, and we'll sort of talk about that. So we have kind of one question, statutory construction or remedy. Two, we have kind of the governing test, which is legislative intent. Would Congress or would a state legislature prefer what's left when the unconstitutional part or unconstitutional application has been excised, or would it prefer nothing at all? And then the final point is how should a court deal with a severability clause, which are quite common, and I suppose you could also consider an inseverability clause. And the severability clause essentially says if any part application is held unconstitutional, we want the rest. We want everything else. And the current doctrine is that's treated as a presumption in favor of severability, but it's not that much different from the presumption that would otherwise obtain. Which, so if we're thinking in a textualist frame, is sort of odd. And one thing that, so when I had written my piece, I argued in favor of a more remedial view of severability. And when I was reading Professor Harrison's later piece, preparing for today, he sort of emphasizes there's actually been somewhat of a remedial turn in the law of severability, which is the Supreme Court still uses the same test, and I think they still often refer to it as a matter of statutory construction, but increasingly there's an idea of this is really a remedial matter. And so what is the remedial view of severability? That's sort of something that I want to talk about, which is making its way into the law. It certainly hasn't displaced the sort of traditional view, which is incredibly long-standing. But so the remedial view is sort of three different things. One, the plaintiff gets the narrowest remedy available. That's the remedy that cures the constitutional violation. When you're a plaintiff and you've sort of showed the court that the government has violated your constitutional rights, you get the remedy you get has to fit the violation. So you get the narrow remedy, and that kind of produces the guiding principle that the court is supposed to save and not destroy a partially invalid statute, which is something the court has said for decades and decades, though they haven't viewed it so much in terms of remedial, but it fits the basic remedial rules as well. So second, in devising a remedy, the court has to strive to respect the legislature's handiwork, which is kind of a basic remedial rule. It also kind of tacks on and is the root of kind of this idea of we care about legislative intent. And so if you're worried about looking at legislative intent in a statutory construction mode, it fits better in a remedial mode. And then third is the court has to be mindful of separation of powers and avoid substantially rewriting a partially invalid law. The court said this recently, I think, through Chief Justice Roberts. Editorial freedom belongs to the legislature, not the judiciary. In other words, the court should avoid using severability to engage in radical surgery. And in some sense, these are competing. Saving and not destroying it might require some kind of rewriting. The question is it the kind of radical surgery that the court is really sort of overstepping its boundaries? And I think much more so than the legislative intent test, this reflects sort of some of the questions the courts should be asking when it comes to severability. And I think it is ultimately tied more to remedy than statutory construction. One, you could sort of think temporally. It's usually considered at the tail end of the court's analysis of a case. You start with jurisdiction, you start with standing. The court construes the law. It makes an effort to avoid a constitutional problem. When it's done that, it then reaches the merits, and then severability, at least most of the time, comes sort of at the tail end when the court is thinking about what should the decree be. Should it be This law is invalid as to this particular plaintiff. Should it be something broader? So I think in many respects it does fit into thinking of it as a remedial matter. Second, so we have this long idea that severability is a matter of statutory construction, but it's not really construction in any usual sense. Statutory construction is about heeding the text, and severability is not. There's no text to heed other than severability clauses. But in a case where you have no severability clause, there's no text that you can sort of look at to get the answer to severability. It's not really understanding about what the words mean, but whether the statute should be held unconstitutional in part or in toto, which really fits more, I think, into the remedial camp. And as such, remedial concerns deserve more weight in the analysis. So you could think about this as, under the rubric of saving constructions, you both have avoidance and severability. They're both ways of saving a statute. A court could say, NFIB is in NFIB you sort of have both examples. You have Chief Justice Roberts using avoidance to say the mandate should be considered a tax. You also have him using severability, saying even though I find a problem with the Medicaid expansion, the answer is severing. So you have these two ways, but they differ in that avoidance comes before the constitutional analysis, and it's actually statutory construction, though when the court is construing the statute in avoidance, it's also thinking about constitutional concerns as well. Severability, it's really not statutory construction in any sense of the term. So I think, one, I think it's calling it statutory construction fits poorly, and I think looking at it as a remedy kind of is a more grounded analysis. I think the main problem that courts struggle with in severability as it's understood is that it asks this counterfactual question. If the legislature realized this part was unconstitutional, would it have wanted what remained, or would it have wanted no law at all? Now you have the instance where the legislature thinks about it, and we talked about the Boucher case where they devised a fallback law. But the fallback law is, I think, sometimes you see those, but they're a rarity where the legislature says, I see this constitutional problem, I'm worried about it, I'm going to devise a solution so the court will know exactly what I want. Most of the time, they don't do that. Either they're silent or they have this incredibly broad severability clause. And I think courts tend not to give them weight because it's saying, I don't know what the constitutional problem is, but whatever it is, whether it's small or enormous, I still want you to save the rest. And I think, although the courts have been saying such severability is a matter of legislative intent for decades and decades, there's, I think, pretty pervasive distrust of severability clauses to the point that right now the law is they establish a presumption, but that presumption is one that obtains really in the absence of a severability clause. And I think the way severability clauses are treated is sort of a test of whether it's statutory construction. If it was purely kind of statutory construction, there would be your textualist answer. They said sever, so sever whatever the result it produces. And courts have not gone there. They don't seem interested in going there. And I think part of the problem is it's understandable that a legislature wants as much of its statute saved, but it's much harder to explain why it would prefer the court get rid of the entire thing. And I think a good illustration of this problem is a recent severability case out of the Supreme Court called Murphy versus NCAA. This was a 10th Amendment case involving a federal sports betting law. The court struck it down in an opinion by Justice Alito that I believe was joined by 6 justices. They found it a violation of the anti-commandeering doctrine under New York and Prince. And then they proceeded to strike down the rest of the law. And Alito's main argument was what remained once that the challenge provision was struck down really didn't make sense as a coherent whole. And to me, when you read his analysis, it feels wooden. He's trying to explain why the legislature wouldn't have wanted it, but it's not really tied to any legislative materials. It sort of feels very speculative, and I think insofar as his main point was, we've kind of cut out the heart of what Congress enacted when it passed the sports gambling law. We're not going to sort of rewrite it and produce a wildly different law. It would have been a much stronger opinion that simply went and said that, rather than, I think, sort of a more tortured effort to try and phrase it in terms of legislative intent. So, and the last point I sort of want to emphasize is, if you look at severability as a remedial view, with the sort of three principles that I started with at the top, I think it sort of largely accords with what the court has done, even though they've been much more focused on legislative intent. One, the main rule that's focused in most of the cases is the idea the court should save and not destroy. You see that with NFIB. You see that in the Free Enterprise Fund case involving the Sarbanes-Oxley Act. You see that in abortion cases like Ayotte versus Planned Parenthood, which insists that sometimes the narrow relief is the best. The court should find the narrowest way to cure the constitutional violation. And I think Roberts hits on this. He says, the narrow remedy with respect to Medicaid expansion is fully remedies the constitutional violation. It respects Congress's basic objectives, and imposing that remedy kind of fits with basic remedial principles. The plaintiff gets the narrowest remedy, and I think as sort of these cases, which sometimes I think liberal litigants are disappointed, sometimes conservative litigants are disappointed, but it's a reflection that normally the court orders the relief that fully remedies the constitutional violation and doesn't go any further. There's certainly exceptions. So Murphy is one example. There are a number of, there's sort of a counter tradition in some free speech severability cases where the court says, we're going to leave more line drawing to Congress. We're not going to step in. But then there are also counterexamples like Booker, where the court saved a statute, in that case the sentencing guidelines, with really quite a lot of rewriting, sort of changing mandatory sentencing guidelines to discretionary ones, and the court said, look, this is consistent with what Congress wanted to do when it passed the sentencing guidelines, and that's all that severability requires, even though the dissent had a pretty good case. Wow, you've really rewritten the statute in major ways, and it's Booker's. It's almost even worse, because not only did they rewrite it in Booker, but what they left in place was so vague that they've had to keep rewriting it, and the court has had a lot of cases kind of fleshing out what was the meaning of the remedy that Booker rewrote. But that's again, so that's part of the canon. I mean, I guess sort of turning towards the ACA, I think against this backdrop, sort of the joint dissent, which urged invalidation of the entire ACA, including sort of everything in all 900 pages, including many provisions that were sort of far from the constitutional problems. The joint dissent identified stands as an outlier, and it sort of didn't give much weight at all to the normal remedial role that the plaintiff gets the narrowest remedy, and the court's obligation is to save and not destroy. It relied very heavily on the argument that the ACA couldn't function in the manner Congress intended, but that's always true in severability cases. Since you've taken something out, it's not going to function in the way it. The question, again, that the court sort of always poses is, would Congress have preferred what's left or no statute? And I think in that case, the joint dissent really sort of dodged that question. And to my mind, it sort of brings back a point that sort of history sort of tells us, is that sometimes severability can be abused by a court sort of striking down more than their constitutional analysis gets them. And sort of some examples to think about in this respect are the very end of the 1930s conservative Supreme Court in cases like Carter versus Carter-Cole. They used severability to strike down New Deal legislation they disliked, and you can go even back further to the post-Reconstruction era and look at cases like United States versus Reese, where the court used severability to invalidate Reconstruction era civil rights law, knowing that Congress, with Reconstruction over, wouldn't be passing any more federal civil rights laws. And then, I guess so that sort of tees up the next panel. I'll just sort of end by pointing out, in many respects, the Texas versus U.S. case is kind of a severability case that breaks the mold because we have this sort of second snapshot. Of course, Congress zeroed out the penalty tied to the individual mandate, which I think pretty clearly makes the point that the rest of the ACA could survive without a mandate backed by sanctions. So the judicial guess that you often have in severability cases, isn't really here. We have kind of this second-in-time view where Congress recognized we're fine keeping the rest of the ACA even if the mandate has no sanctions. And I think that's going to make it a very uphill battle. But I think briefing is happening pretty soon, and we'll see and watch very closely. Thanks so much.
That particular piece of fur will fly on our second panel, I think. And we can say within the bounds of terminology and categories, but I guess not to stifle any cross-panel rebuttals and counter-rebuttals, which you may have as well. We get caught in this set of, at least we start out with bright lines and rules, and then we're suddenly sliding in, well, on the one hand, on the other hand, the other hand. So, David has argued on occasion that, whatever legislative intent is, it dials it up, dials it down. It's not a particularly rigorous test. I guess, John, what I'm asking is, you have your preferences, but looking at the array of how this has been applied in practice, do we have enough of a binding framework where you have some predictability? I guess the ACA always wins, but beyond that, as to how severability is going to be conducted and whether the judiciary is straying into other lanes?
Two things about that. First, just as a description of general severability approach, I think that there's a certain amount of unpredictability. I think that the language I quoted from Alaska Airlines, that sort of deeply embedded series of quotations, that basically describes it. That is to say, there is an operative presumption in favor of severability. And that's not an absolute bright line rule, but it is meaningful. It actually provides guidance. The other thing I want to say about that is this is, and this connects to some of the things David was saying, questions of inseverability overwhelmingly are questions in which the courts are going to be in a situation of severe uncertainty precisely because they are dealing with a contingency that was not the basis on which the statute was primarily drafted. And that creates difficulties, and that creates difficulties in particular for textualists, although textualists know there are unforeseen contingencies that the statutes have to be interpreted in light of. And therefore, what the courts are doing when they have things like presumptions of constitutionality, and therefore the courts are coming up with ways to decide how they're going to decide in light of uncertainty. And when they do that, they are perhaps inevitably making some policy judgments, because what they're doing is deciding which kind of error is worse than another kind of error, because in cases of uncertainty, that's the crucial thing. And so inevitably, to some extent, the court's policy judgments are going to be involved here. And then, of course, I don't want to be unduly realistic about the judiciary, but anytime there is a hard question, well, guess what may influence their decision. So, but to some extent, they're doing their own sort of policy thinking is legitimate and unavoidable because they're dealing with uncertainty. So
it's Congress made a mess and it's clean up on aisle 5.
And it clean up on aisle 5 without being told which part of the problem do we address first. That's sort of that's.
I want to get to some of David's policy incentive aspects of analysis.
So I think there is there's both some amount of predictability and some amount of so one, there is kind of a strong inclination to giving the narrowest remedy, and you see that. But I think often, in bigger cases, there's sometimes that gives way, and you have the sort of doctrinal framework of legislative intent is very malleable, and because you're asking a counterfactual on which there's usually no evidence, I think you can often make arguments on both sides, and the court doesn't really have tools to litigate them, so it's very easy for their own views
But
to
they can
slide
produce
in.
a fast remedy, whether or not it's the right one, than going back to Congress.
They can produce right. So the chief advantage of severability is sort of speed. There's no sort of lag time of sending something back.
That's close enough for government work, as far as I can tell. You talked about, in your other earlier article, the incentive structure. I mean, you pointed out quite well that every legislature believes as much of its work should be saved as possible, regardless of whether they premeditated which parts were more important than others. So there's a built-in bias. What kind of incentive does that provide, though, in legislating, if you know you might have a safety valve in the judiciary?
So there's, and this is something that I think the court kind of hits on a lot, which is that there's a worry that the courts will do the job of tailoring a law to constitutional concerns as opposed to the legislature. That's something that I think Breyer mentioned in the whole women's health case, that also came up in the Yachty case. It's something that goes back to some of the court's own older severability precedents. It's counterbalanced by the fact that we don't always have this sort of pure we don't have a pure system of legislative intent. We have, and I think Murphy is sort of an example of this, sort of concerns about rewriting sort of and being incorporated into the analysis in a lot of recent cases, which is sort of assigned to a legislature. If there's a major problem, the court might fix a minor one, but and all the if you look at the counterexamples where the court gave a broader remedy, they tend to be ones where there wasn't a small fix, there was a bigger one. And you can debate kind of among those cases where they should have come across the line.
Okay, one of the places we started out structurally was the idea of separation of powers. John, I was discussing this issue with a mutual friend of ours and past colleague of yours, Tom Christine, and he raised this question for you. If a line item veto is unconstitutional, does treating a statute as consisting of discrete portions for purposes of severability analysis create an asymmetry in the powers of the three branches?
Well, my answer to that is going to be, in principle, no, precisely because I don't think that severability is something courts do, precisely because I think it is something the Constitution does. And hence, there's a difference between a line item veto and courts engaging in excision, because if courts are doing what they ought to be doing, they're not doing the excising. They are finding it and not making it.
If they're doing what they're doing.
Well, right, and then the next point is going to be that to the extent that they are indeed influenced by their own policy judgments, the way the president is legitimately so in exercising the veto, and a governor is legitimately so in exercising a line item veto, they should stop.
Okay, we'll wait on that one. Lower court rulings. You gave the traditional view that they're only giving a ruling within their jurisdiction and it doesn't have larger impact. I know you've spoken on this elsewhere. We've seen some federal district courts issuing nationwide injunctions. So sometimes those rules don't seem to hold. What's going on?
That is another important question that's gotten a lot of attention recently, and it is related to a couple of things I was talking about. This is the situation where, say, the federal government has a program. There is one party who's affected by the program and seeks an injunction against carrying out the program one way or another, and the injunction that the court gives is don't carry out the program at all. And it's normally put in terms of being nationwide. The actually interesting phenomenon is when the court is in effect providing relief to non-parties, somebody other who did not sue. And it is certainly true that makes it possible when a lower court does that to do something that is like what the Supreme Court of the United States does when the Supreme Court sets a nationwide precedent. Because when we say the Supreme Court has invalidated a statute, I think what we really mean is they have set a precedent that every other court will follow, that the statute is invalid. So the problem of the so-called nationwide injunction, relief to non-parties, is a way in which a single trial court can go beyond what trial courts normally do by exercising a remedy. Notice, and this then becomes a part of both the law of remedies. Under what circumstances can a court that has one plaintiff before it give a remedy that in effect extends to a whole lot of other plaintiffs? That is to some extent governed by the law of remedies. I think in some of these cases the lower courts have made an error with respect to how broad the remedy should be under principles about, as David was saying, the remedy is supposed to remedy this plaintiff's wrong and not somebody else's. There are also questions having to do with, beyond the law of remedies, an Article 3 standing problem. That is to say, the courts have often said it's a principle of the scope of the judicial power and the nature of a case or controversy that a party is entitled to a remedy that remedies only that party's problem and not somebody else's. So a lot of the same issues come up in those cases. Yes.
But I mean, the issue about nationwide injunctions is in many respects far afield from severability.
It's all part of just doing the right thing. We're impatient people, and we just want to get to the bottom line. And however you get there tends to be the case.
Well, right. Lots of people like nationwide injunctions when they're getting.
Well, it depends on what. Yeah. And one great thing about this topic is both oxes have been gored in the last several years, so it's to some extent possible to have some real perspective.
There are oxes all over the field. Along that kind of continuum, we've got these different categories and tools, but constitutional avoidance, does that end up migrating back and forth into severability, into how you decide these cases? Do these items fall into these slots and categories, or does the court get stuck with a problem and says, how are we going to get out of it?
I mean, I tend to, I'm not sure how much migration there is back and forth, though. I'm not.
But they are alternative ways to deal with it.
I mean, they're both ways to save a statute that's attacked on constitutional grounds. They do it in very different ways. When the court is avoiding, it then is construing the statute, and as Scalia pointed out, then the statute has that construction kind of going forward, even as to other cases in which there's no constitutional problem to avoid. And that was the Martinez case. And avoidance is both constitutional interpretation and statutory construction. And that, I think the Martinez case sort of illustrates that. And the court at least sometimes says, we can't take avoidance this far. And there are loads of cases where people say, they point to a case. I think, I certainly recall Namudno, the precursor to Shelby County, being a case where people said, boy, Chief Justice Roberts kind of pushed the limits of what could be called avoidance because he didn't want to reach the merits. So, I think they have their own dynamics. So I'm not sure courts sort of say, we're going to do avoidance to avoid severability.
They wouldn't say it out loud, no.
I'm not even sure they think about it. I think mostly if they're thinking about avoidance and are, perhaps going further than the typical case, it's because they don't want to reach the merits, not because of something connected to severability.
First, on constitutional avoidance is where a court construes a statute in a particular way, not to avoid saying the statute is unconstitutional, but to avoid having to decide whether it's unconstitutional. And that practice has been criticized, I think, to some extent legitimately, for encouraging courts to bend statutes, like the case David was just talking about. I do want to say, and this illustrates something I think that's important about severability, there is an important configuration in which a court quite legitimately and properly avoids the constitutional question in a case that poses a severability issue. That's where the party before the court is saying, I'm subject to something that's constitutional, this is like Alaska Airlines, but there's this other thing that's unconstitutional and it's inseverable. It is perfectly legitimate, and I think better, for the court to address the severability question first, making the point severability doesn't always come at the end, because courts sometimes do what I'm about to describe, to say, that may be unconstitutional, but if it is, it's severable. So you, person subject to the thing that's okay, you have no grounds to complain either way. Either it's constitutional or it's severable, and you're subject to the other provision. I think that's absolutely right. I don't think that is illicitly ducking anything. I think that's addressing a genuine statutory construction question, the question of severability. Courts should do that.
I mean, I agree with that. And if you look at the sort of the older severability cases, there were many more of those. I think, maybe now we have litigants who, they make sure they have the plaintiff who is challenging the thing they're complaining about. And so I think if you look in recent cases, there are fewer cases like that, though perhaps, NFIB was one where that was an issue, and maybe that's an issue going forward. But more of the time you see cases where severability comes at the end.
Well, we have sui generis when it comes to NFIB and the ACA. Look, we have both a general audience and a media and a legal audience. So let me bastardize this. This is always the case, which defies actual conclusions, which is, okay, thumbs up, thumbs down. What kind of job are the courts doing on severability? A few slips here and there, but we know basically what's going on. There are some hard cases on the margins, or is there some slack and some softness in what the courts say as opposed to what they do?
I mean, as I said, I actually think it's moving in the right direction. That doesn't mean there aren't cases. I find Booker sort of quite problematic insofar as it's they substantially rewrote the very part. It wasn't that there was another part that was related to what was held unconstitutional. It was the very part that was held unconstitutional, and the court has had to kind of continue sort of rewriting the law because of the lack of clarity.
They'll get it right eventually.
But I think in some of the ways I mentioned, they're at least distancing themselves from this idea that it's simply a question of statutory construction, which I just think doesn't make sense, and they are incorporating it more into remedies. Though again, they're perhaps they're not they're not doing that fully, but you certainly see evidence of this in a number of recent cases, and it's not. I think the court is ending up largely in the same place because they're instead of talking about legislative intent, they're talking about you get the remedy that fully remedies your constitutional violation and not more.
I think just in general, I would give them a pass, but not an honors grade. They are doing.
They're probably just auditing it anyway.
Doing okay, but could do better. Right, exactly. And the Supreme Court could give the lower courts some more useful guidance. I will say about the remedy question, as I said, I think most of the time it doesn't matter. Most of the time, one opinion could be written in terms of severability as a remedy. Another opinion that reaches exactly the same conclusions and uses basically the same considerations about legislative purpose could be written in the terms that I would find more correct. Wouldn't make a difference. Now and then it does make a difference, as, for example, the court came within one vote of what I think would have been a very serious error of treating it genuinely as a remedy and saying that plaintiffs who do not have standing with respect to the ACA should nevertheless be entitled to get the Supreme Court to say the whole thing is inseverable. So I think that the remedial understanding of it is an error. It's a figure of speech run amok, and they should get that under control and not do that.
All right.
The standing issue in some ways is presented in sort of a subset of cases, and that I take it is still sort of open. The court could continue treating it as a remedy in cases where you had standing to do so, but say, there are limits, and we won't even consider severability in cases where there's a standing issue.
All right, I've awarded everybody their 3 credits of continuing legal education if you're not members of the bar. We're going to thank our panelists, take a very short break just to change hockey lines, and we'll be back in about 5 minutes. I assume all of you guys are okay just talking from where you're sitting? Okay, so it's going to be a swap? That's fine. Okay. Yeah, I know what you mean, the desk thing. Look at those. Are those buttons? No, those are just anchors.
I don't need PowerPoint on it.
Okay, no, I thought you went lower, raise it?
No.
Oh, okay. Okay. All right, everybody, let's get ready to go. You have 10, yeah. If within the margin of error. Okay. All right, welcome back, everybody, from our brief break, a little longer than I wanted, between panels. We're now going to take up the severability issues in Texas v. United States, as applied, as it were, although it also could be considered a full facial challenge in light of the December federal district court ruling. The very quick recap, that court ruled on partial summary judgment that the individual mandate in the Affordable Care Act, as amended by the last Congress, has become unconstitutional as of January 1, 2019, and the rest of the law cannot be severed and saved to QED. Now we're on the way to the Fifth Circuit Court of Appeals, and the House of Representatives under new management just joined this litigation party. A few stipulations up front. There are other significant legal issues in this case that could short-circuit another run at severability on appeal, standing, whether there's something unconstitutional that happened, and a few other lesser cats and dogs. But as much as possible with 4 litigators on an afternoon panel in Washington, we are not going to get bogged down in those items and instead move ahead to our separate hour of argument over what if severability, sort of like the Supreme Court did back in March of 2012 in NFIB v. Sebelius. So we'll have 4 opening rounds apiece with no hitting on the break. And up first is Josh Blackman, and I will introduce each speaker separately because they all have to insist upon being introduced, even though they need no introductions. Josh is an associate professor of law at the South Texas College of Law in Houston. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technologies, the author of a few books, Unraveled, Obamacare, Religious Liberty, and Executive Power in 2016. Before that, Unprecedented, the constitutional challenge to Obamacare in 2013. And among other things, he's the founder of Fantasy SCOTUS, the Internet's premier Supreme Court fantasy league. Many of the real rulings are enough of a fantasy, but aside from that, he's the author of over 4 dozen law review articles, including the upcoming Undone, the new constitutional challenge to Obamacare, which was, to say the least, very influential in Judge O'Connor's December 14th ruling in Texas v. United States. A full disclosure, I had to invite Josh here in order to ensure that I get mentioned in the index of his next book, pending a Fifth Circuit ruling and Supreme Court grant of cert. Josh Blackman.
Thank you very much. For me, talking about Obamacare feels like the movie Groundhog Day. It's the same script that repeats itself over and over again. We all know what happened, and we all know what will happen. We just don't know how quite we'll get there. My analysis today doesn't focus on the mandate. Jim gave me fierce instructions. I will assume that the Supreme Court finds that the mandate is unconstitutional following the Tax Cut and Job Act of 2017. I'll just assume that. Okay. The resulting question then is, what is the remedy for this constitutional violation? I think there are 4 possible ways that the Supreme Court can go. First, the mandate and only the mandate will be enjoined. Second, the entire ACA, all of it, will be halted. Third, the mandate plus guaranteed issue and community rating are blocked. GI and CR, these are the provisions that ensure that insurance companies can't discriminate against sick people. And the 4th provision is a bit unorthodox, that the correct remedy is to kill the tax cut. That is to restore the penalty at about $700 a year, give or take. So let's go through the options one at a time. First, if the court finds that the mandate is unconstitutional, then they have to declare the mandate unconstitutional and say that will not give effect. This remedy will not have much of an impact beyond the people on this stage. I would take it as a salutary victory for the rule of law. I've actually come to grips with Chief Justice Roberts and FIB. I've accepted it begrudgingly that this was his best way of reading the law. And if his idea that the law can be saved because the mandate raises revenue, and the mandate no longer raises revenue, that now it's constitutional, I'm happy. Again, no one else will care about that, but I will be very happy with that ruling. I'm beyond. I'm underwater at this point. But I would be happy if the court simply declared the mandate unconstitutional and went home and said the rest of the law survives. Okay. That's option one. That's easy. Option two is the remedy that Judge O'Connor adopted in Texas. And for full disclosure, Judge O'Connor cited my writings in 4 or 5 different places, so he found my things influential. That's probably a sign he's wrong. But the challengers proposed the remedy, you have to kill the entire ACA. And they based this remedy on the arguments advanced by the joint dissenters in the NFIB decision. Right? We had Justices Scalia, Kennedy, Thomas, and Alito, and they argue that if the mandate is unconstitutional, then the rest of the ACA must fall. Even back in 2012, right, before all this went on, I was skeptical of the all or nothing proposition. I thought that aspects of the ACA could possibly be salvaged. The Medicaid expansion, perhaps a few other provisions, probably would exist independent of the ACA. So I didn't fully agree with the joint dissenters back in 2012. I could be persuaded, but I was still a little bit on the fence about this. But Judge O'Connor found that the remedy that should be adopted is to kill the entire ACA pursuant to basically what the the dissenters did in 2012. Okay. I want to focus now primarily on options 3 and 4, which I see is where a lot of the attention should be focused. In 2012, Solicitor General Verrilli argued to the Supreme Court that there was a remedy to be had. If the court found that the mandate was unconstitutional, the correct remedy was to declare the mandate unconstitutional and also chop off the guaranteed issue and community rating provisions, the GI and CR. Now, why did Verrilli make this argument? Right? Why did he say that the court should strike down other parts of the law? The Obama administration took the position that the mandate was essential to the pre-existing condition protections. Okay? And it didn't make this argument up at whole cloth. It looked to findings in the statute, right? The ACA didn't have a severability provision like we usually know it. It did have express statutory findings in which it said in different places, I think at least twice, that the mandate was essential. That's the word it used. Essential to the operation of the GI and CR marketplaces. And Verrilli argued that without the mandate, these provisions couldn't function. Okay. Maybe you agreed with that in 2012, maybe you didn't. I found it actually pretty persuasive in 2012, but that doesn't matter. Fast forward till 2017. After the Tax Cut and Jobs Act was enacted, Attorney General Sessions, who's been in the news recently, made a finding. And he argued that the Trump DOJ would not defend the mandate and would also argue that the GI and CR provisions would have to go if the mandate was unconstitutional. He defended the rest of the ACA, so he didn't quite go as far as Texas. He said, I am keeping the same argument that Verrilli adopted 5 years earlier. Now, I know the common response is, wait a minute, Josh. We know exactly what Congress thought in 2017, right? They didn't want to kill Obamacare. They made the decision that the ACA can exist without the mandate. I agree, right? As a matter of politics, the mandate never actually worked. I think the penalty was always too small, and it was not effective at nudging people into the insurance marketplace. There were lots of exemptions and waivers, and it wasn't enforced well. I'm with you. But that's not the only question we have. There are different ways of measuring legislative intent, right? Now, Congress can express its findings in a statute. Congress can express its findings in a committee report. They can express their findings in a floor statement, right? They can express their thoughts in a press conference. Hell, now politicians can express their thoughts in a tweet, right? That's now admissible evidence in any federal court. So if you were to poll the members of Congress in 2017 who voted for this bill and say, can the mandate exist can the ACA exist without the mandate? They'll say, yeah, sure, the mandate's not necessary. That doesn't win the day, right? That's not enough. And the reason why are these statutory findings I mentioned. These are findings that Congress adopted by bicameralism and presentment. They're in the law. They've not been repealed. The mere fact that Congress did something inconsistent with these findings does not affect an implied repeal of those findings. Now you may say, Josh, wait a minute, these findings are not enough to save the law. Maybe that's right or wrong. But the mere fact that Congress took an action inconsistent with the statute doesn't render a duly enacted statute invalid. So I think Sessions was actually correct to look to these findings. Now, I think Sessions screwed up. He could have defended the severability with ease. So I don't agree with his decision not to defend the GI and CR. But I think there's a credible argument, right? I think there's a credible argument that because Congress hasn't repealed those findings, as a matter of law, the mandate was still essential. And that's why I think there's a good position to take. I haven't actually come to a firm conclusion, but there's a good position that the GI and CR provisions have to go. Now, would this be the end of the world? No. Almost every state in the union has some form of guaranteed issue in the book, right? If we repeal guaranteed issue tomorrow in California, these other states suing, nothing would change. Their GIC are even more strict than the federal standard. This is not like our other favorite case, King v. Burwell, where if the challengers won, states would lose lots of money. States are fully competent to enact GI and CR. It's popular as hell. In fact, I wish Congress would enact a single-page statute imposing GI-CR as an independent basis. I don't care about healthcare policy. It's irrelevant to me. I mean that sincerely. It's not my thing. I do care about faithful application of the law. So I think it's a plausible solution for the court to kill the GI and CR in the same ruling that Verrilli argued in 2012. Now, option 4 is the funkiest, and I mean this. I didn't buy it at first, but I've come around to it a little bit, right? Let's think of it this way. In 2017, Congress did something bad. They took a statute that was constitutional, and they made it unconstitutional, right? They knew, or they should have known, that by dropping the penalty to 0, they were rendering the ACA unconstitutional. I knew it. I was watching. I was like, wow, man, they just made Obamacare unconstitutional. I was watching the debate, right? I'm sure their staffers realized this. How then do you resolve a constitutional violation where later in time Congress does something to render an earlier in time statute unconstitutional? Well, there's an old case. It's old, from the 1920s, called Frost versus Corporation Commission of Oklahoma. An old case, but still cited every now and then. And Frost teaches a lesson that when you have this sort of later in time action that renders an earlier statute unconstitutional, the remedy is to kill the amendment. You heard me right. The remedy would be to actually reimpose the penalty. Then everything's copacetic, right? We're back in John Roberts' world. Everything's happy. I know this sounds nuts, but I think there's actually some weight here, right? If we take the position seriously that what Congress did in 2017 was unlawful, then the remedy is to kill what Congress did in 2017 and raise the penalty back to $700 a year. Now, I don't go full hog on this remedy because I don't think it's available in Texas versus United States, or Texas versus AZAR, whatever they're calling it nowadays, right? Why? No one in the Texas case challenged the tax cut. Courts don't have this sort of red pencil they can just strike out any provision of the U.S. Code they want, right? There are a limited menu of options available in the Fifth Circuit, and I don't think one of those options is killing the tax cut. Now, in Maryland, the Attorney General of Maryland, his name is Tom Goldstein. Actually, he's not, but Tom is their de facto AG, filed a lawsuit challenging the tax cut. Now, that's a funny question about standing. Do you have standing to challenge a tax cut? Right? They're removing a penalty from you. It goes back to the mandate debate. I don't think Tom has standing. I think it's a problem. I don't think you can challenge the tax cut because it's actually removing a burden, which you can say the same thing at the mandate. We go in circles all day. But I think you have to give some weight to the argument that the possible remedy is reimposing a tax, which then creates an even more bizarre circumstance. If the Supreme Court rules that all these people didn't pay a tax have to pay a tax, we're all tax delinquents, right? Now we have to pay back taxes, and there's penalties, and I don't even know what that. So in other words, this case is messy. It's messy. It's unpopular. No one likes it except for maybe me and 3 other people, right? This is not good for Republicans. It's not good for really anyone. But I start from the principle that I believe John Roberts. He made his ruling. I believe he thought that was the best ruling he can have, and let's see if he stands up for it. Thank you all so much. I look forward to your questions and answers about Obamacare or the wall or anything else. Thank you.
Thank you, Josh. You were able to come out in favor of 4 different positions somewhat, which
tried.
is a good goal, and it's good for business.
I tried.
Our next speaker is Ilya Somin. He's professor of law at George Mason University, author of a number of books, including Democracy and Political Ignorance. So we have more of the latter than the former, but why smaller government is smarter. That's right. And The Grasping Hand, Kelo v. City of New London, and the Limits of Eminent Domain, and also co-author of A Conspiracy Against Obamacare, the Volokh Conspiracy in the Healthcare Case. He spent a number of years as co-editor of the Supreme Court Economic Review, previously clerked for Judge Jerry Smith, the U.S. Court of Appeals for the Fifth Circuit, so he's been in the Fifth Circuit before, interestingly enough, and Ilya also earned a J.D. from Yale Law School, and he's on the brief, one of the briefs that is quite critical of the plaintiff's argument in Texas v. U.S., and I suspect he'll be filing more often again in the future on that front as well as others.
And
Ilya.
he was my property professor at George Mason, so always an honor to sit with Ilya.
Josh's most important credential, which wasn't mentioned, is that he's one of my former students.
Thank you.
I can't imagine that was omitted in his bio.
You can go up. Yeah, that's fine.
So I'd like to start by thanking AEI for organizing this very timely event and all of you for coming. I'm very happy to be here, though I'm not entirely happy to be in the position of having to defend Obamacare because, like Josh and others here, I was involved in the earlier Obamacare litigation. I argued that the mandate in its original form was unconstitutional, and I'm still unhappy that the Supreme Court decided things that way. I'm also unhappy that in 2017, the Republican Party, for the most part, failed miserably in its attempts to repeal Obamacare. My main objection to most of those attempts was that they didn't go far enough. Nonetheless, I do not agree with the severability argument that was put forward by the 20 states in this case, or the slightly more narrow version of it that was endorsed by the Attorney General. And I think if it does persuade the courts, then it would make a hash of severability law, and it would also set a potentially dangerous precedent, which is why I joined in the brief that was mentioned a moment ago. So as you saw earlier in the previous panel, there's a lot of disagreement about how severability doctrine should work and how the court should handle this. I don't propose to resolve that disagreement here, but I think on any reasonable theory of severability, this particular argument that the newly neutered mandate is inseverable, that argument should fail. And I'll go through several different versions of severability theory and explain why that's so. And then at the end, I'll talk a little about the dangers of the precedent that would be set if the severability argument advanced by Texas and the other states were to be accepted by the courts. So as you heard previously, the standard view on severability is what did Congress intend? This is the rhetoric the Supreme Court uses. Would the Congress have wanted the statute to be kept in place, the remainder of the statute to be kept in place, if this one part is struck down? And in this instance, if in any case you can figure out what Congress's intent is, here it's pretty clear. They themselves, in 2017, essentially neutered the individual mandate. They removed all possible penalty. If they thought this was really essential to the rest, they would have kept the penalty, or at least would have kept some sort of penalty. So their actions very strongly indicate their intent that they don't believe that this is all that important to the rest of the statute. If they did believe it, they would have let it have at least some teeth. And the court, by the way, has said that Congress can express its intent not just in findings and statements and the like, but in the actual text of their law. Making the mandate completely toothless is a pretty powerful statement of congressional intent. At the very least, it suggests that Congress prefers a situation where the rest of Obamacare, or most of the rest of it, stays in place, whereas the mandate gets neutered or eliminated entirely, to a situation where either Obamacare gets repealed entirely or one where the mandate is kept in place like it was before 2017. Now, Josh and the plaintiffs in this case, they say, well, what about those 2010 findings that say the mandate was essential, right? There's a lot of them, or those statements by the Obama administration and others. I think it's pretty obvious what those statements refer to is not the mandate as it exists since December 2017. It's the mandate that existed before with the associated penalty. I think you can look far and wide and not find any member of Congress or the administration or any other critical political actor who thought that, or who thought then or thinks now, that what's really essential to Obamacare and its operations is a mandate that has no teeth whatsoever. This just isn't true, and no relevant political actor, to my knowledge at least, believes it. And so therefore, those 2010 statements, even if they're in some sense still binding, they're binding only with respect to a version of the mandate that doesn't actually exist anymore. They're not binding with respect to the one that's before the court, which is the one that's essentially neutered. And I agree that the neutered mandate is now unconstitutional under John Roberts' reasoning. The court can and should strike it down, but that doesn't mean that the rest of Obamacare is inseparable from it. Now, some people say we shouldn't look to the intent of Congress. Maybe even some argue that intent is just a meaningless concept when you're talking about a multi-member body with hundreds of different people. What you should look at sort of how does the statute actually work? What would be the practical effect on the rest of the statute of removing this thing? And such calculations can get murky. As John Harrison mentioned in the earlier panel, they might descend into policy judgments that are contestable. But in this case, I think it's pretty obvious that removing a mandate that has been completely neutered would have virtually no effect on the operations of the rest of the statute. I think that's pretty clear, and therefore, from this sort of more practical approach, you end up with a similar result. Finally, there's some people, including the recently appointed and confirmed Justice Kavanaugh, who argue that what we should really be doing, or what courts should be doing in the area of severability, is to, as he puts it, cut the statute to the narrowest extent possible unless Congress has indicated otherwise in the text of the statute. Cutting to the narrowest extent possible means just removing what's left of the mandate, not removing the entire thing or removing large parts of the rest. He does mention the text of the statute, but the text of the statute nowhere says that the mandate as it currently exists is inseverable. Indeed, nowhere does it even say that the original mandate was inseverable as such. It just said that it was essential or extremely important to the operation of the rest. Whether or not that was true of the original version of the mandate circa 2010, it's not true of what's left now. Finally, what happens if, contrary to my expectations, the Fifth Circuit and ultimately the Supreme Court buys the severability argument that's advanced by the states? I think it would set a potentially dangerous precedent, and one that people on different sides of the political spectrum have reason to worry about. One big potential impact of this is that it would make the courts in the future reluctant to strike down parts of laws. If striking down even a relatively small part of a big law means that there's a good chance the whole thing has to go, many courts will be very hesitant to do that. Now, maybe if judges who are as libertarian as I am would not be hesitant, they would say this is a feature rather than a bug, but probably 99% of judges are not like that. They will hesitate to create a situation where the entire statute is lost for want of a small nail, particularly if it's a politically sensitive major statute like the ACA. So therefore, I think the end result of this will be the courts will be tempted to allow a lot more unconstitutional activity to go through, which strikes me as a bad thing. Similarly, Congress might become more reluctant to repeal parts of statutes. Obviously, if the key swing voters on the December 2017 Tax Act, if they had thought that this would lead to the collapse of all of Obamacare, they probably would not have voted for the act. People like Murkowski, Collins, the late John McCain, and so forth. And if in the future Congress thinks that repealing one part of a law a big major law could cause the whole thing to come crashing down, they would be less likely to do it. That too strikes me as not a very positive consequence of going this route. So I don't know for sure what the courts will do. I think ultimately they will not go for the severability argument on appeal and in the Supreme Court, but I admit I could be wrong about that. Screwy, surprising things have happened previously in the Obamacare litigation, so we'll have to see what happens, but it seems to me that
on any reasonable interpretation of severability doctrine, this particular severability argument or this particular inseverability argument deserves to lose. Thank you.
Thank you, Ilya. You conjure up visions of whenever you approach ACA litigation, you're nearing the Bermuda Triangle, and the usual instruments don't seem to work. Our next speaker is Jim Blumstein, University Professor of Constitutional Law and Health Law and Policy at Vanderbilt Law School, and is Director of Vanderbilt's Health Policy Center. He served as Principal Investigator on numerous grants concerning managed care, hospital management, and medical malpractice. So you have someone who actually knows health policy here as well as health law, which is only an option, not just a feature, maybe a bug. He was elected to the National Academy of Sciences Institute of Medicine, was awarded the Earl Sutherland Prize, which is Vanderbilt's preeminent university-wide recognition for lifetime scholarly contributions. He also served as former Tennessee Governor Phil Bredesen's counsel on TennCare reform, not as campaign manager for the Senate race, I believe, and has participated actively in a number of Supreme Court cases, arguing 3. Jim is a creative litigation strategist, I would point out. Some of you may recall he was the key developer of the Medicaid coercion argument that led to the ACA's Medicaid expansion becoming a voluntary option for the states in the 2012 NFIB v. Sebelius ruling. Jim Blumstein.
Thank you. Thank you. Thanks to Tom for including me in this very distinguished set of panels and fellow panelists. It's been several years since I was at AEI, and I remember under Tom's leadership, we had a program before the NFIB versus Sebelius case in which we talked about Medicaid expansion, and Tom was very much facilitating that discussion, and no one was really interested in that part of the case except a few of us academics who put forth the theory. I want to start by recognizing that people can sometimes say things that have meanings that are kind of the opposite of what they expect, and I think sometimes in litigation this is true as well. And I love to tell Yogi Berra stories, but the Yankees, when he played for the Yanks, trained in St. Petersburg, and he was waiting for his buddy Mickey Mantle outside the training facility, and he was dressed in a T-shirt and shorts, and there was a young woman with a tank top and shorts, and she saw Yogi and said, "Yogi, you look pretty cool." And so Yogi said back to her, because she was dressed the same way, she said, "Well, you don't look so hot yourself." That's not really what he meant to say. I don't think, but that comment has more than a temperature dimension to it, and so sometimes things we say are not exactly what we mean, and that was a bit of a malapropism. First, I want to quickly go through the background. Josh and others have touched on this, so I'll kind of run through this. But basically, in constitutional law, the federal government doesn't have inherent powers, unlike states. There must be a source of authority to act. And with respect to the Affordable Care Act, the government put forward basically 3: the Commerce Clause, the Necessary Proper Clause, and the taxing power. The Supreme Court clearly, 5 justices, held that the Commerce Clause and the Necessary and Proper Clause did not provide a constitutionally valid basis for enacting the Affordable Care Act. The Chief Justice split with the other 4 in that coalition of 5 justices and concluded that the Affordable Care Act could be justified under the taxing power, and only under the taxing power. And so when Congress in 2017 passed a bill as part of a tax cut bill, it undercut the constitutional foundation or basis for justifying the individual mandate in the Affordable Care Act. It was no longer revenue raising, couldn't be seen as a tax, and I think other fellow panelists have said this. Ilya, I think I heard him say, I don't want to put words in his mouth, but I think I heard him say that he agreed with that part, that the stripping away of the revenue and the tax law undercut the validity of that portion of the Affordable Care Act. So the question then is, how far does the relief go? is the relief limited to the individual mandate itself, or does it have legs beyond that? And so here's where we get into our discussion about severability. And basically, I don't want to kind of redo this, but essentially the bottom line on severability is you leave as much of the law intact as you can, you give effect to congressional will, and then you ask, and this was added in the Murphy case, is the end result one that Congress would find or that the court would find is acceptable? And we have examples of where the court has struck down laws. I'll mention today prominently where the court struck down or invalidated laws, very significant laws. The Graham-Rudman-Hollings legislation was struck down in its entirety, and the line item veto legislation was struck down. And yet we have other examples like the sentencing guidelines, like the Booker case, where the court is kind of trying to find what cuts can be made and to retain the overall theory. I find the Booker case not to be very satisfying as a matter of judicial surgery, but there are precedents on both sides. And so my bottom line here is that severability doctrine is quite imprecise. There are some broad parameters, but there's tremendous amount of judicial flexibility. And the courts are asking a difficult question of whether some excisions can stand, or whether, as a result of some of the excisions, the whole law must fall. And that is to say, a court may undo the entire structure because of the uncertainties of what Congress would have wanted, the uncertainties of how all the pieces fit together, whether you have so much that's cut out that you have essentially a termite-infested structure, and the whole thing has to go as a result. And so I think there's an element of political determination as well, and to dress it up with my former teacher, Alex Bickle, who talked a lot about dialogue between the courts and the political branches. And ultimately, the idea is if courts undo a portion, who should redo the legislation? And Bickle was famous for saying that's a dialogue where courts should kick back to Congress and let Congress redo the political dimensions. In my reading, that's essentially what the district judge did in the Texas case, is that he kicked it back and said, we're going to undo everything, and then force the Democrats and Republicans, as much as they don't like to talk to each other these days, to come back and provide a political fix. And I'm going to undo everything, set the table, and in a sense, force the parties to come back and renegotiate this. So in the ACA, and Justice Ginsburg says this in the NFIB case, tried to retain a market-based approach, not a Medicare or a Social Security approach. Justice Ginsburg recognized that Congress could have established a social welfare approach, but didn't do so. What the objective of ACA was to keep a market-based approach in place, and then to offset some of the adverse consequences of the market-based approach when you add these social welfare provisions to it. So that's basically what they tried to do. And what makes a market work in insurance is that a market assumes that there are similarly situated people in a pool, and maybe 20% in the pool are going to get really sick, 80% may not really have a good deal out of their insurance, and at the end of the day, you buy into the pool because you think you may be one of the 20%. In a sense, you hope it's the 80%, but in any event, you pay in willingly because you're insuring against a risk that may occur, not one that has already occurred. And the problem with the guaranteed issue provision is that it undermines insurance. There are a lot of things you can say about the guaranteed issue provision, but you can't call it insurance. It's not insurance. any more than buying life insurance when you've been diagnosed with cancer. Everyone knows intuitively that that won't work. Or with my students, I give the example of your neighbor has a fire and the wind is blowing in your direction, and you call your insurance company and say, oh, sign me up for fire insurance. Well, it may be that you really need fire insurance then, but it's not insurance. It's a form of after-the-fact social welfare judgment. It's a social insurance idea, not a traditional insurance idea. So what crosses the gap here? What marries these two ideas of traditional insurance and social insurance? And the problem is that you need some folks willing to pay the 80% so that the 20% in the insurance pool who need it can get their health insurance. And by the way, I always like to tell the students, I never feel cheated at the end of a year when I don't collect on my life insurance. I never feel cheated that I lost my premiums. Actually, every year I celebrate in January. I made it through another year, and I'm very happy. And I've yet to feel cheated. But that's the idea. But if I
give you a lousy T-shirt.
but if I follow the rationale of guaranteed issue, if I got sick during that year when it was too late to sign up and had a pre-existing condition, that would be gaming the system. And it would be in my interest. I would much rather buy insurance when I know I really needed it. But that's not the nature of insurance. So there are many things that you can say about guaranteed issue. You can't say it's insurance. It's just not insurance. And to say it's insurance is a misnomer. That's why I started with Yogi Berra. It's not insurance. It's social insurance, if anything. And so then the question is, what did the ACA do? The problem is there's no incentive to sign up if you can always get insurance, and that will diminish the pool. And states had that example beforehand, a dozen states or so, and there was a death spiral. Well, there may not be a death spiral now because of the subsidies, but it has adverse consequences. And so when you take the mandate away, which is what the 2017 tax law did, we can expect that there will be many fewer people who will not sign up. And that takes away the deal because you no longer have a substitute for a market. The substitute for the market was coercion. In a market, you don't need coercion because the incentives are to sign up if you want to insure against the risk. Once you have guaranteed issue, you need to find a way to put dollars into the pool so that the sick will really have the dollars necessary to support them when they get sick, when they need it. So, as I said, there may be a need for coverage, but the guaranteed issue is not insurance as we know it. So the government recognized this, and no one has talked about this, and I'm surprised in the context of the ACA. People care about pre-existing conditions. This last election showed that that was a big concern. But in my terminology, what that means is that there's a strong constituency for treating health care as social insurance. And in fact, the new wave or the new articulation of single payer is really to transform and to get rid of a private insurance market and to transform medical care into social insurance and to give up on traditional insurance. And that's a hotly contested issue. Certainly the politics were not there in 2010. So what does that mean in terms of what the ACA did? The ACA wasn't going to kick in for 4 years. It was passed in 2010. It became law operative in 2014. And so the benefit of insuring those who have pre-existing conditions was going to kick in at the same time that the coerced payments, the individual mandate, was going to kick in. And the Congress recognized the two were inextricably linked to each other. But that didn't mean that there wasn't a problem between 2010 and 2014. And what did the ACA do? It created high-risk pools for those 4 years. It didn't create a mandate for even-handed treatment for those with pre-existing conditions. This was a recognition that one was inextricably interrelated with the other, is that you had basically 4 years in which the problem of people with pre-existing conditions was going to be handled not through a non-discrimination rule, a civil rights paradigm, but through the actual funding of pools. And Tom has written about this, and I actually think that's the long-run solution. If the Republicans know what they're doing, they will find a way to fund coverage for those with pre-existing conditions and not undermine the insurance market. But we'll see. That requires appropriation of real money. And people say they care about this issue, but they're not willing to pay for it. So, I mean, some of this is a shell game. So, but the high-risk pool strategy was in the law, and it was in the law until the individual mandate kicked in. Okay, so will the market work? There's some evidence that the subsidies will offset the experience that we saw in the states before the enactment of the Affordable Care Act, but still, no one disagrees. So, but we don't know. The new law just went into effect last month. That's a lot of projection by the Congressional Budget Office. We don't know where that's going to turn out. But the CBO thinks that the subsidies will end the death spiral. But certainly, they don't deny, and nobody can deny, that for the 20% or 25% who are not subsidized, the prices will spiral tremendously. And I think clearly Congress would not have caused this kind of effect for the 25% had they known that that's what was going on in 2010. So I think ultimately when you look at the history, the reality of what Congress did, and then ultimately the insight of the Justice Department and the enforcement mechanisms, I think that the deference that's owed to the Justice Department as the enforcer, ultimately I think, and that's where I was before the district court decision, I think that where the Justice Department came out is likely where the courts will come out, where the Court of Appeals will come out, and I think ultimately the Supreme Court will come out on this case, and some deference will be given to the Justice Department on that, and this internal justification within the Affordable Care Act itself. Now, what the surprise was in the district court opinion is how far-reaching the invalidation was. And I must say, I didn't think the court would go that far. I've reread the joint dissent in NFIB. I've read the district court's decision here, and I've moved from, I don't think that's what's going to happen, to an agnostic position. I think it's not unreasonable to expect that a court will say, basically for dialogic reasons, and also because fixing the law requires something like the Booker case, the sentencing guidelines case, where the court is going to have to figure out what stays, what doesn't stay, what stays and what doesn't stay. And I think the district court, I think, did quite a good job. There's been a lot of criticism. I know that Ilya has written about this, but I think it's actually Jonathan Adler and Abby Gluck, who are on the brief, wrote a rather uncharitable op-ed piece on this. I think it's a tougher case. I think it's a harder case about what the right answer is. And it requires courts to figure out and to repair what a political determination is about who are the winners and who are the losers. There are taxes in this law. There are reductions in payment to Medicare in this law, all premised upon an architecture that is supposed to fit together. And if you lose one part, I think you go back and ask the hypothetical, what would Congress have done? They won no Republican votes. They won in the Senate, they had 60 votes, which was the minimum they needed to offset a filibuster. And so any single senator would have killed the bill. And many parts of the bill were aimed at getting the individual votes. Harry Reid was a master at crafting together the politics of the Affordable Care Act. So at the end of the day, I think the question is, what is the role of the court here? And the court has often said that it wants to play the least political role possible, the most deference. And that's a fair question to ask. What is the least political role? Is it to figure out whether the insurance companies are getting unduly screwed or not? Is it to say whether the Medicare reduction in hospital payments was inappropriate, or the payment for these various taxes that were designed to pay for the benefits? Hard to say. And under the circumstances, I've come towards leaning, although I'm not quite over the line yet, I've come towards leaning to think that the district judge is right in this case, that the politics are such that courts can undo, but the Congress has to redo. And this is the Bekelian idea of dialogue, is that ultimately there's enough support for the Affordable Care Act, other provisions, that by putting this into the political forum, there may actually be a salutary effect, which is, guess what? The Democrats and the Republicans may have to talk to each other. And it may force the conversation where grown-ups will be in the room and have these conversations. As Tom mentioned, I worked for Democratic Governor Phil Bredesen when we were doing TennCare reform. I would recommend that he be involved and help to solve this problem as a good kind of mediator in between person, a Democrat, but who doesn't mind talking to Republicans, and in this case, hiring one to help them do TennCare reform. So I think that's where I am at this point. Whether the court finally, should the court go there, is its institutional integrity at risk? I think this is something the court has to weigh. I think it will turn ultimately on two of the justices who were not here, Chief Justice Roberts, who didn't opine about this issue. And part of me says they should take the easier case, which is support the Justice Department position. There's another part of me that says the court can really help to repair the political system here, but it'll come at some political cost to the court. So what would I do if I were on the court? Stay tuned. It's hard to know. I ain't going on the courts, but stay tuned for what others are going to do. And I could see, even if I were asked by some of the justices what to do, I could see a fair case to be made on both sides. And I have to end by remembering Harry Truman's comment about he always wanted to have a one-armed economist because all the economists he consulted said on the one hand this and on the other hand this. That. And I'm sorry, on this issue, I'm a two-armed economist, not a one-armed economist. I think there are strong arguments that cut both ways, and neither side is frivolous. It's asking for projection about political outcomes that I don't feel is certain at this point. Thank you.
Thank you, Jim. We could, on the other hand, just line them up end to end is another way to deal with one-armed economists. We're a few grown-ups short of that room you're envisioning, but we'll see what happens. I should have mentioned earlier, since you alluded to him, that John Adler was unable to make it today. He was too busy getting ready for his Strange New Respect Award as our one-time ally.
What's
we
that?
kid, we kid because
Respect?
we love.
I wouldn't know.
It's an old Tom Bethel American Spectator Award, first given, I think, to Justice Kennedy, but a long line of Republicans who had grown in office or otherwise received it about 25 years ago, or more or less. Our final speaker is Ted Frank, Director of Litigation and co-founder of the Hamilton Lincoln Law Institute, a public interest law firm. He's argued a number of Supreme Court cases, federal Court of Appeals cases, winning a number of landmark decisions on civil justice reform issues. The New York Times calls him the leading critic of abusive class action settlements. Wall Street Journal referred to him as a leading tort action advocate and praised his work exposing dubious practices by plaintiffs' attorneys in class actions. On the other hand, he wrote the vetting report of vice presidential candidate Sarah Palin for the McCain campaign, so there's that as well. You win some, you lose some.
Is that in his bio?
You got to
I
look
didn't
hard
write
for
that
this.
in my bio. Everything I've been doing the last 10 years is to get that off of the first line of my obituary. But
It's good penance. Just to complete the rest, because Ted's done a lot of important work. He's formerly a legal scholar here at the American Enterprise Institute and also at the Manhattan Institute. He's on the executive committee of the Federal Society's litigation practice group, and he clerked for Frank Easterbrook on the Seventh Circuit and graduated from the University of Chicago Law School. Ted Frank.
thanks for having me. It's a privilege to be back at AEI, and this is my first time on the game show stage, so excited about that. We heard in the first session Ronald Reagan talking about the importance of simplicity, and I will endorse that by not repeating so much of what we've heard before because so many of the panelists have covered what I wanted to cover. So let me endorse Professor Blumstein in saying that what Congress has done has created an incoherent statute that does create problems and possibly dooms it to a death spiral. But in the world of justice, words of Justice Scalia, he wished he had a stamp that said "stupid but constitutional," and I think that's what we have here, because I endorse what Professor Soman said about the severability arguments, and to that I'd like to add, I am definitely one that when you're trying to divine congressional intent, you don't look at the tweets, you don't even look at the committee reports, which can be often written by lobbyists in hopes of influencing later courts. And who's to know what the intent of Congress is when you have 435 legislatures and 100 senators on top of that? But here, this isn't a close question on these things. We know the intent of Congress was not to repeal Obamacare in its entirety, because they tried to do that and they didn't have the votes. We know whatever the intention of Congress was, it was not to reaffirm the findings of what they did the initial time around, because they took the initial Rube Goldberg device of the ACA and its mandate, which was strikingly ineffective because it wasn't harsh enough, and then they completely nullified it and turned it into a hortatory command. And of course, government does hortatory commands all the time. You have commercials breaking eggs and talking about drugs and telling you not to smoke and things like that. And they've turned Obamacare into the same sort of hortatory command with perhaps even less effectiveness. So we know that despite the death spiral that they've probably doomed the ACA to, the intent was not to get rid of the ACA in its entirety. It was not option 3 that they wanted less issue and the like to die. So we're left with Josh's option 1 and option 4. And to me, option 4 has a certain appeal to it. You have a statute that not only is constitutional, it's quote-unquote unquestionably constitutional because the Supreme Court said so. And you now have an act of Congress that has arguably done something that is unconstitutional. And I think here we're sort of getting into an eschatological choreography because we've been asked to assume that what Congress did was unconstitutional in turning the mandate into a hortatory command. But once we have that assumption, well, what follows from that? We have a constitutional act, and then we have an unconstitutional act. You can undo the constitutional act and restore the constitutional act that was passed by Congress. Ted, that's absurd. You're now saying that the courts are creating a tax increase, and I will acknowledge that is pretty absurd, which I think creates the underlying problem with the initial assumption we're making that a tax cut is somehow unconstitutional. But now that we have that assumption, one way we can undo it is by undoing the tax cut, because we have, or we can take what a Justice Kavanaugh would probably do is what is the narrowest thing you can do, and that's the option 1. You hold the mandate as a whole is now stricken because we have decided that the hortatory command grants you standing to ask for it to be held unconstitutional. So here it is, it's unconstitutional. There's no more hortatory command, and everything is exactly the way it is because we don't. I don't think there's anything in the record whether the hortatory command actually forces people to do things that they don't want to do. As we know from the initial first few years of Obamacare, the problem is that even the $700 or so penalty was not enough to get people to buy insurance, and was dooming the entire Rube Goldberg device to a sort of death spiral, which is now accelerated. As much as I hate to contradict my former client, Professor Blackman.
My professor and my lawyer both screw me over. This is awful.
Former lawyer. So I can be against you on a different matter.
No conflict.
As much as I hate to disagree with Professor Blackman, who's obviously had far more influence on this area of the law than I have, we have, I don't think the court actually has the problem with the blue pencil of rewriting statutes, and we know this because we've seen Justice Roberts do it. We saw him do it in Free Enterprise Fund versus Peekaboo. We saw him do it to a certain extent when he declared the mandate to be a tax, notwithstanding everybody insisting that it wasn't a tax and getting the law passed. And to a certain extent, we saw him do it in King versus Burwell. So if you're making predictions about what the court's going to do, even assuming that they get to the point where they say that the tax cut and hortatory command is now unconstitutional, or grant standing for somebody to ask for it to be declared unconstitutional, I don't think that they're going to be reluctant to either take option 1 or option 4 and strike what the more recent act did. So that was, hopefully very simple, and I see I'm well within my time, so we have more time for questions.
That was fine, Ted. And let me just start off in this way. I didn't have to go outside the Federalist Society to generate disagreement on this. This is a pretty wide dispersal pattern, and you could argue about the magnitudes within the membership. Is it just the bizarre nature of where we've been with the ACA that leads us in this place? Or is there something underlying in how the courts go about their business that maybe brings this more to the fore? Is it an institutional problem or a one-off of just a long, strange trip in terms of this piece of legislation?
Oh, this is a long, strange trip. And I think the biggest difference between the ACA today versus the ACA in 2012 is a political force. Every Republican is falling in line with the ACA's protection for guaranteed issue. And the notion that a court could then set those provisions aside would be devastating to the Republican Party. Right? I'm not popular for what I'm doing. Right? Texas is not popular for what they're doing.
We don't need to talk about your personal life.
Oh, no, my personal life, there's none. This challenge is not popular. So the dynamics are very different. President Trump, in the same breath, says, I want to protect pre-existing conditions and also want the court to set aside the pre-existing conditions. It's very difficult.
So there's been a lot of interesting and unusual stuff in the ACA litigation to this point, but I think this case is very different in its dynamics from the previous ones. The previous ones largely divided the expert community along ideological lines. If you were a conservative libertarian constitutional law expert, high likelihood you thought that the individual mandate and the Medicaid expansion were unconstitutional, which I did think. Whereas if you were a liberal, high likelihood you thought they were perfectly fine. Here, Josh is almost the only expert of any prominence who have publicly spoken out in favor of the position either of Texas or the one the Justice Department has taken. So this is sort of a more screwy and weird argument. That doesn't by itself mean that it's wrong, although I think it's wrong for substantive reasons I explained before. But I think whereas the previous litigation divided people along standard lines of division about federalism and mandates and the nature of congressional power and the like, so that you split them along lines, which you've seen for a long time in the community of experts around this issue. This case, I think, is more of a moonshot or more of a Hail Mary, whatever you want to call it. That doesn't mean it's absolutely impossible for it to succeed. Sometimes, the Miami miracle happens, and much to my annoyance as a Patriots fan, they got that Hail Mary and scored the 69-yard completion on that weird pass. But this, I think, is more like that than what we saw in the previous rounds of Obamacare litigation.
Sounds like the phrase you're searching for is orphan lawsuit. We're not having many paternity files.
Well, there are 20 states that are filing it.
That's correct. The AGs.
So there is some political muscle behind this lawsuit, which gives it some measure of credibility. But it's striking that in the expert community outside of those immediately involved politically, there's very little support for the severability argument. There is a lot of support for the argument that what's left of the mandate is unconstitutional. I support that myself, but the big political stake is on this other stuff. Does it invalidate any of the rest of the ACA?
But it's not only ideological. I think part of the issue is what happens once the law would be repaired in the way you describe. And I think then you have the Justice Department as the enforcement agency coming in and saying, given our expertise as the enforcers, at least the guaranteed issue part and the community rating part have to go. It's not a political choice. And that's where I think Josh's insight that the politics have changed could lead to a bigger bang. And I think the fact that the politics have changed would suggest that the court would say, here's a time for dialogue. And that's what the district judge in Texas has done, is to say, we're not going to kind of piecemeal this. Ultimately, it's not targeted only at one part of it. It's the whole law is going to have to fall and be redone. So, I mean, I don't think I'm still not there myself about where I think it's going to come out. But I really disagree on the question of guaranteed issue and community rating. I think that there will be deference to the administration, and that would be a way to split this. And I think that ultimately that may or may not be popular. I think the Republicans would be smart to have in place a stream of dollars for high-risk pools, which I still think is the better way of dealing with pre-existing conditions rather than, in a sense, undoing the insurance market.
Is there a statute of limitations on, for want of a better phrase, owning up to past fictions? I mean, we've built a big pile of things that supposedly this law was about, the program was about, and then we've moved that line in different ways. This is really a timing issue. I know you're arguing the 2017 Congress pretty much blew all that up. And Josh is saying, no, some of the stuff they did in 2010 still matters, whether it's the findings of fact. Once upon a time, CBO said a lot of stuff that those cannons don't fire in the same direction the way they used to in terms of the impact of the mandate. So where's the intent, and whose intent at what point in time, and what was Congress doing or not doing, or is everybody pretty much out to lunch?
Sure. I'll take just a slight exception with my former professor and my former attorney who was ganging up on me. I don't think that it's a neutered mandate. And if you don't believe me, that's fine. In November 2017, the Congressional Budget Office and the Joint Committee on Taxation wrote a report. And the report said, quote, with no penalty at all, only a small number of people who enroll in insurance because of the mandate under current law would continue to do so solely because of a willingness to comply with the law. That's not Josh, that's this Joint Committee on Taxation, CBO. The number's small, right? I don't know what that number is, but it's a fairly small number. At least for some people, the mandate still has a legal effect. And if that mandate still has some legal effect, it's small, it's bitty-bitty. But if that mandate still has some legal effect, then Congress's findings in 2010 about the mandate being essential still hold. And in the findings from 2010, there was no mention of the penalty. There was only a mention of the mandate. If you read John Roberts' opinion on the mandate, he doesn't even mention the penalty. The litigants in 2012 understood the mandate and the penalty are different legal provisions. It was litigated that way, NFB was written in that way, and I think it still exists today. I think the mandate is basically a non sequitur for most Americans, but for a small number of people, it does matter. And for that reason, I think Congress's findings in 2010 should still be given some force.
So I think those findings clearly apply to the law as it existed at the time, and the assumption was that it wouldn't be just limited, the effect that they were seeking to that small number of people who would be influenced by this even without the penalty. What they wanted a much larger number of people so as to avoid the kind of problems that Jim Blumstein was talking about. So I think it just defies belief that those findings were either meant or understood at the time or any time since then to refer to a mandate that's neutered in the sense that it only applies to a small number of people whose decisions would actually be changed by it. If you want to push the neutering analogy somewhat farther, you might say that some sperm are still swimming through the channel, but not nearly
knew we were
enough.
going
but-
there.
but not nearly enough to actually impregnate anybody.
It only takes one, Ilya.
And I don't. It only takes. Actually, it takes more than one to give you many more than one. Actually, many.
We're not even in the
to give
first
you-
I'm staying
trimester.
out of
to give you a higher than to give you actually a statistically significant chance of causing a pregnancy, and that's what's going on here. There's just there may not be enough sperm even with the $695 penalty. There definitely aren't enough without any penalty.
What if that
at all.
one sperm is Michael Phelps?
So it's.
I'm done.
Okay. Well, it's
I'm done.
All right,
Still not enough.
we'll move out of that
done, I'm
bank.
done.
Does
Yeah, but I think that there are 2 points about. I had this listed as kind of to talk about if we in the Q&A. I think all that we can look at in the 2017 law is that it was a tax law, and there were internal constraints within Congress about what could or couldn't be considered. So now there's an argument that, okay, the Republicans tried and didn't succeed in repealing and replacing, and there's a broader political context. I'll address that second. But the first is, I don't think you can draw the inference that the Congress had said, well, we'll leave it the way it is. We think that's best. I think the most you can say is that Congress didn't address that issue. And it did what it could under the rules. And what it could do is it eliminated the tax. And that has the effect of making the rest of the law, of the mandate unconstitutional. Now, what one can determine from political failure, certainly this is not a frivolous argument, but I think it's not a persuasive argument at the end of the day. One can point to Youngstown Steel and the concurring opinion of Justice Frankfurter, in which he talked about Congress's consideration of seizure, and then not voting for it was tantamount to prohibiting it. Okay, so if I were writing a brief, I would cite that and that support. But ultimately, that doesn't really pass after the Chadha line of cases, which is to say that the problem with that is the president didn't have a chance to veto, and it was never presented to the president. So ultimately, I think that part of Youngstown Steel is on very questionable grounds. And to draw an inference about what the Republicans could or couldn't do in 2017 is not strong in light of the internal structure of the ACA itself, the phase-in of the provisions on guaranteed issue, the risk pools, and so forth. So ultimately, I don't think it's a frivolous argument, but I think it's not a persuasive argument.
How much of this is what people criticize lawyers for doing, which is you're stretching something as far as you can in a literal sense and saying we're going to, make you be stuck with it until you can get out of that box? Because, we have the overlay of what this is supposedly the official language said one thing, and the underlying reality turned out to be very different.
Can we talk about politics for a minute? I think ultimately, we are all academics and we want to see how courts handle these things. But there's another political dimension here, is that the Republican Party used an awful lot of political capital to put 2 justices on the Supreme Court. I think Chief Justice Roberts can't be ignorant of that. He is trying to maintain some independence and so forth. But there's a political dimension. The Trump supporters will go berserk if they don't get something out of this deal.
It may already be there.
Well, if they don't get something out of the deal, which would be a minimum of what the Justice Department says is enforceable. So, I think we can't be totally ivory towerish here as well, is that there are a lot of blood and sweat that went into the Kavanaugh appointment, the Gorsuch appointment, to the president's constituency supporting the appointment of judges who will see the law in a certain way. And so I think that's kind of an overlay here that we don't like to talk about. I don't like to talk about it. But I think one has to see that. And the courts can come away with taking out a middle ground, and which will be the Justice Department position, which is where I ultimately think that they'll come out. But to ignore that is to ignore the reality.
Well, in 2012, staring down the barrel of the gun, it was like, no, we can't do this because of other things that real-world practical consequences. We're 7 years later, maybe 8 years later. This is an awful lot. I mean, I know we've got examples of courts knocking out big programs. That's an awful lot to unravel, even if you try to buy some time and pretend that the parties will come together. Doesn't that just put like a practical curb on whatever you might want to imagine in Supreme Court Fantasy League, as opposed to what real people do?
I mean, one major difference in the political change is when you're striking down Obamacare in 2012, you still have a functioning market that the world can return to. And that has been wiped out by 7 years of ACA. And there's nothing in place for it. And it would be chaos. And there would be a lot of political capital for the Supreme Court to come down with a 5-4 decision, getting rid of guaranteed issue and community rating. And it's not just Justice Roberts that wants to preserve that, but Justice Kavanaugh, who had a very contentious confirmation proceeding, so I'm told, has an interest in demonstrating himself to be an independent justice and not Trump's puppet.
So chaos is someone else's brand.
So I think if we're going to look at political aspects of this and how those might influence the courts, there's both sort of a doctrinal aspect and a broader political aspect. The doctrinal aspect is that if you're going to look at the politics or whatnot and consider it in terms of measuring congressional intent, then you can't have it both ways. You can't, on the one hand, say, well, what the 2017 Congress doesn't really count in terms of intent because of the rules about taxes, but at the same time ignore the broader context. In fact, they did it as a tax measure because they couldn't get the broader type of repeal. If Congress had wanted the broader repeal and had the votes to do it, they would have been able to. So I think that's pretty crucial. On the question of the justices and their political calculations, probably some Trump supporters might be disappointed if this case doesn't go the way that Texas or the way that the Justice Department wants it to go. But if you look at where Trump's core support is, it's not among the people who really want to get rid of community rating or guaranteed issue. It's among people who want to do things like build the wall. And if anything, Trump, relative to the other GOP candidates in 2016, was noted for his total unwillingness to cut social welfare programs like Obamacare or like Social Security, Medicare, and the like. And he always claimed that he would keep the pre-existing conditions, things in place. So I doubt that the justices will feel like they've disappointed some big Trump constituency if they don't go Texas's way on this. Whereas on the other hand, Roberts may well feel, and Kavanaugh and others as well, that they will spark a massive backlash on the left and maybe even on the center if they do this, which they're very conscious, I think, of things like that. The left is talking about possible court packing when and if they get into power. So I don't know if that stuff will really have an impact or not. I think they could just resolve this if it even gets to the Supreme Court just based on fairly simple standard severability doctrine. I don't believe this is a close case on that. But if they do start weighing these non-doctrinal calculations about where is the biggest political risk, it is likely that the biggest political risk from John Roberts' point of view is in striking down all or most of the ACA, that he will regard that as more risky than either choosing one of the other options, the simplest of which is just simply to get rid of the residual mandate, or alternatively, something we haven't talked about, to say, well, there's no standing here. That's a possible ruling.
And
Let me pile on John Roberts for a minute, if I may. This is his fault, right? If John Roberts had just said this is an exercise of the commerce power, go home, we wouldn't be sitting here. For the last 7 years, I thought, maybe Obamacare becomes unconstitutional. It's like Schrodinger's mandate, right? Depending the price of the mandate, the penalty goes up and down. There was even a blog post in 2014 where there was one place in California where paying for insurance was actually less than paying the penalty for some rich people. I said, Obamacare is now unconstitutional. I was thinking of standing, right? This is Roberts' fault. He created this bizarre reality where you have this fluctuating mandate that hinges upon these guardrails of the penalty being raising revenue, whatever, right? We're here because of him, and I was going to make another mess to make even a deeper mess. So I blame John Roberts for a lot of things.
A lot of people deserve blame. I opposed the tax ruling. I thought it was just straight up unconstitutional. It's not a tax. His sort of Rube Goldberg contraption of why it is a tax, very few people are particularly persuaded by that. But in fairness, it's also the fault of the Republican Party for not being able to get together to come up with a more effective Obamacare repeal. It's the fault of the Democrats for designing Obamacare the way they did in the first place. It's the fault of the public for their poor understanding of economics and public policy for voting for the politicians who did this. So there's plenty of blame to get around it, to go around here, but I'm not convinced that blowing up severability doctrine is the way to get out of the situation.
You left out the libertarians. You were spreading that blame around.
So I think most of us are largely blameless. We oppose we oppose the enactment of Obamacare. We oppose the individual mandate. Most of us in total, and to the libertarian healthcare experts have a variety of policy proposals that wouldn't rely on this kind of contraption to try to increase access to healthcare and reduce costs.
I think
so
we've
if
been,
our fault is that we don't have more influence than we do.
Two things. I think we've been very fortunate that Chuck Schumer and Nancy Pelosi have not gone to President Trump and said, we would like to get rid of Obamacare and replace it with this single-payer health care program we call Trump Care.
Scottish version.
And we don't have a president with a coherent policy framework. And if they had done that, we would have a president who would endorse it and then a base that would support it 80%. Now, the Democrats might oppose it 80%. And that might, and we might find that the country is now 60-40 in favor of the free market. But, and Ilya has written very persuasively on that sort of political ignorance. But everywhere where Justice Roberts has disappointed the conservative base, it's where he's been following, and it's interesting that we mentioned Bickle, because I've always thought of Roberts as being a conservative in the Bork-Bacalian sense, most of all, but in the sense of really the least dangerous branch, and restricting the court to only intervening where it comes down to the political structure of the First Amendment, of political speech, and the political workings of the Constitution, and everything else narrow and defer to the political branches. And if you look at that framework, that explains Free Enterprise Fund. That explains what happened in the first two ACA cases, and I think it will predict what happens if the Fifth Circuit puts the Supreme Court in the position of having to decide this.
Yeah, I think that I agree with Ted on this issue with respect to the Chief Justice. I may be the only one who thinks that he actually handled the tax issue correctly from a broader Supreme Court role point of view. I don't disagree that doctrinally he was not on strong grounds, but in terms institutionally, for a court to strike down a popular administration's major social legislation looks very Loechnerian, and I think ultimately, I think for the
person next to him,
for good old days,
for the court to find a way to uphold the legislation, even if it's on, dare I say, trumped-up grounds, I think was actually institutionally justifiable. It was not, as I said, it was not the only answer, but I think it was not even the best answer, which he acknowledged, but it was a plausible answer. So I think in 2012, that was not an although I would have preferred a different outcome, I actually supported his outcome. I think that this becomes a reasoned and reasonable position. I think the world has changed in 2019 from 2012, and I think that my sense of kind of where things are, and my chief piece of evidence for that is how the Supreme Court just handled the capital punishment case. I've lived through these. Yes, thank you. Well, that's a bad way to say it. I've witnessed, because we had 3 executions in Tennessee this last year, and I've seen how the abolitionists handle these capital punishment cases, and it's turned me from a kind of middle-of-the-road person to a pretty tough on the defendant's person on how this has been handled. And finally, I interpret the court saying enough is enough. These are issues that can be important. They can be adjudicated after this person is dead. There's 10 other people waiting. If we really have to have an imam in the chamber, if that's a First Amendment requirement, fine. Someone else can raise it. This guy's committed a heinous crime, and he's going to be executed. And I think that explains how they wouldn't give a hearing, that they've had enough. And I think that that's ultimately where 2019 is different from 2012.
There have been a couple of quick hedging remarks about, if this gets past the Fifth Circuit to the Supreme Court, and we're not yet at Supreme Court Fantasy League. So let's dive down into the Fifth Circuit for just a moment. I think Josh Neely has good feel for that more recently. It's a different kind of composition of the judges there. What's the shot?
Well, was that a question for me?
Yeah, or anybody.
I'll go first. I live in Houston. I pay attention to the Fifth Circuit. It is a fairly conservative court. But more importantly, as these sorts of cases are appealed, they get tighter. I agree with Jim. Judge O'Connor's opinion had some good parts, had some parts that, I think could have been strengthened a bit. And I think that's just
cited you more often.
Yeah, the parts he didn't cite me were the problems. But the problem is when cases start out, they're somewhat raw and new. As they go upstairs, the briefing gets tighter on both sides. Now you have 3 judges instead of 1 thinking about it. If there's an en banc proceeding, I think there are, 11 or 12 judges in the Fifth Circuit? I can't remember. 15, 16? 15.
Yeah.
Thank you, Ilya. 15,
a lot of
15.
new ones.
So there are a lot of judges. This will get better. And again, my one refrain since the outset of this case is don't ridicule this. Don't dismiss it. Don't laugh at it. There are arguments here that might be right, might be wrong, but this is not frivolous. And when someone says an argument's frivolous, and I write a 70-page paper responding to that, there's stuff, right? There are arguments to be had, and some of my arguments have been replied to, and some of them haven't. So I look forward to these arguments being fully vetted by everyone. And Ilya?
Yeah, so I can't know for sure what will happen on the Fifth Circuit. I did clerk there, but that was 16, 17 years ago. But I do think, for the reasons I said before, this is a very weak argument. I don't think, with due respect to Josh, I don't think there's anything in the 70 pages that makes it that much stronger. And therefore, I think there's a high likelihood that the Fifth Circuit will reject it, either just for the reasons I mentioned, or they do have the option of saying there's no standing here, which might be a very tempting argument for at least some of the judges, even though I personally disagree with the view that there's no standing. There's a lot of people who take a narrower view of what's appropriate standing than I do, including a lot of people on the right. And therefore, that's another way that it could be gotten rid of. Now, that said, as I said in my original presentation, we shouldn't be too confident about what might happen with this kind of Obamacare litigation, in that any argument that has the backing of 20 states and of the Justice Department in some sense has entered mainstream discourse, whether it's worthy of entering mainstream discourse or not, and therefore there's a non-frivolous chance that a court will accept it, but I think the odds are against it, and I think more likely than not, this case will die at the Fifth Circuit, either based on standing or based on them ruling that this stuff is severable, and therefore...
Just to understand the sequence, I mean, the Fifth Circuit has to uphold something to get to the Supreme Court.
Well, as a matter of theory, whatever the Fifth Circuit decides, in theory, whoever loses can petition.
In theory,
for cert. But in practice, the Supreme Court almost certainly will take the case only if the Fifth Circuit upholds the district court ruling, at least in part. That is to say, either that they strike down the entire ACA, as Texas wants to do, or they strike down guaranteed issue and community rating, as the Justice Department wants to. If either of those two things happen, the Supreme Court will almost certainly take the case. If the case gets dismissed on standing, or they rule that the residual mandate is severable, then I think it's very unlikely that the Supreme Court will take the case.
And the catch-up Democratic case got knocked out of court recently,
in Maryland,
which would have created a hypothetical conflict.
Yeah. So again, I think if any court of appeals, whether the Fifth Circuit or some other one, rules that this stuff is the residual mandate is unconstitutional, and B, the rest is not severable, or a lot of the rest is not severable, that will get to the Supreme Court. Any other kind of ruling that ends up either kicking on procedural grounds or ends up deciding that The only thing that goes is the residual mandate. That probably will not go to the Supreme Court. That would be my prediction.
I just have to say that I heard the same thing about the Medicaid expansion. Ilya was good enough to say a nice word about some op-ed that I did, but I briefed that and wrote about it afterwards and went around the country speaking about it, and that turned out to be the only winning argument on the other side. And I will say there were many dismissive arguments that we had to deal with on the other side. So I'm not saying you're wrong, but I would also say that the history of the ACA is that surprises come out. I think the fact that the Justice Department's taken the position that it has is a stronger argument for the other
After all, Chuck Wepner went 15 rounds. It's always possible.
Yeah. So I was in a position in the previous ACA litigation. I agreed with the Medicaid expansion argument, but I didn't think it would succeed. And the reason why I and even most of those experts who agreed with it didn't think it would succeed was because we didn't think the court was actually serious about the coercion issue. And it turned out they were serious. But importantly, there was a basis for that argument in the previous doctrine. We just didn't think, and it turned out we were wrong not to think that the Supreme Court was going to enforce the doctrine in that area. Here, there is not even, in my mind and mind of most experts, a basis for it in the existing doctrine, which makes it different. That doesn't mean that the justices can't decide, well, you know what, we want to blow up some of the existing doctrine or reinterpret it. They can do that if they want. That possibility exists. Or they can say, we're going to defer to the Justice Department. Or actually, that's very unlikely that they would do something they otherwise wouldn't do just to defer to the Justice Department on something like this. But it is a different situation.
I don't see how the existing I guess I certainly think one can make that claim with respect to the ancillary provisions, but the Justice Department provisions would not, going along with that, would not be blowing up the previous doctrine. In fact, they would be pretty easy to fit within previous doctrine, which is why I think the Justice Department kind of stopped where it did, and it's based upon both an understanding of the insurance markets, understanding of the phase-in provisions of the ACA with respect to pre-existing conditions, and in terms of intent, I think it's pretty clear. Again, you think the 2017 is important, but I think if you look back to the enacting Congress, it never would have gotten enacted. That's why the Obama administration was so dogged in wanting to preserve the whole structure, the individual mandate. Otherwise, why defend it?
So what gives the game away here is the reference to the enacting Congress. The relevant enacting Congress is the one that created the mandate that exists now, or what's left of it, not the one in 2010. It's just not plausible, I think, to believe that there is a congressional intent, either in 2010 or in 2017, to say that a mandate that's virtually neutered is actually essential to the rest. I think that's the problem under existing doctrine, or frankly, under any reasonable version of the doctrine.
I share my co-panelists' frustration that conservative views on constitutional and controversial issues are often ridiculed and not given fair shakes by academia and the press. But though they laughed at Galileo, they also laughed at Bozo the Clown. And sometimes there are weak arguments that are being made that we should be standing up against.
Let me do a little bit of a heat check for our very patient audience. We've had a long discussion. We can continue it on. I wanted to see if anyone had any particular questions or comments in the form of a question. So let me start down front with Sarah, just to give a fast ID and then your question.
Sarah Hansard with Bloomberg Law. Sarah Hansard with Bloomberg Law. I just want to clarify. It seems like most of you are saying that you don't think that the individual mandate, now that it's been neutered, as you said, you don't think that it's constitutional anymore. You just have most of you think that they won't throw out the rest of the law. I'm assuming you do think that the mandate is still, I'm trying to get a clear reading on, you don't think the individual mandate is still constitutional anymore. Is that what I'm hearing?
I would take the position that a mandate without any penalties isn't really a mandate and doesn't have a constitutional problem. It's no different than a please don't smoke ad. Josh disagrees with me and has whatever CBO finding on that. But in the absence of so much as a slap on the wrist. I think it's just a hortatory speech by the government.
So I think I also disagree with Ted on this a little bit. Not only Ted, but a number of commentators have said, well, if the mandate has no attached penalty, it's not really a mandate anymore. It's like an ad. But I think the difference between this and an ad is that there's still a text in the law which says you must do X. It doesn't impose any penalty if you fail to do X, but the text is still there. And therefore, if what the text tells you to do is something that Congress doesn't have the power to tell you to do, then it's still unconstitutional in my view, even if there isn't an attached penalty. You know, some people say, well, there are a few other laws like this, like the flag code, which has these instructions for what you must do with the American flag, but there's no penalty if you fail to do it, like you hang up the flag in the wrong way or you make it, or you dirty it in the wrong way. I'm pretty comfortable in saying that, you know, maybe the flag code is unconstitutional too. I think the Republic, as shocking as it may be to say this, I think the Republic will survive the striking down of the flag code if this were to actually happen. And I would say the same thing here, that Congress, that if mandating X is otherwise not within the power of Congress, then that law cannot be saved merely by the absence of a penalty. But of course, some respected legal commentators, Ted and others, disagree with that and would say that if there's a lack of a penalty, then it doesn't matter whether the mandate is otherwise within Congress's power or not, because that's just Congress expressing their opinion or something like that.
And I'll add one addendum. The ACA's mandate applies to some people, not others. The law exempts some aspects of the population, Native Americans, people who are incarcerated, those not here lawfully, not others, right? I think this differs from other criminal statutes like the flag burn provision, which applies to specific conduct. This statute applies to some people by virtue of their existence. And I think the mandate still exists and it's unconstitutional.
All right, we'll go back there.
Hi, Paul Heldman with Heldman Simpson Partners. Let's just talk about June 2020, maybe later. I'm interested in
About
your
right.
I'm interested in your timing as question one, but also if the Supreme Court decides to take the Justice Department position or the O'Connor position, how does that play out practically? Does the court create a special master? Do they create a transition period? How do they think about the
this is real
unwinding of the
hypothetical.
law and the new market?
So this is a really good question, and I think it's an additional reason why, if you assume the justices will be influenced by political considerations, this is an additional reason why they might not want to do it. And that is that, you know, as Ted mentioned, this is a really big beast that has been around for several years. It has fundamentally changed the structure of the healthcare market, I think, in not so good ways, other things people think in beneficial ways. But either way, unwinding this big structure is going to be extremely difficult. And there might have to be some kind of transition period for it. There is previous precedent relating to things like what do we do when we've had school segregation for many decades, and do you then have, when we say that's unconstitutional, you then have to immediately desegregate? Similar other cases. Much of that experience with trying to do this gradually under the supervision of judges was not an easy one. It was not an entirely happy one, and the court may be willing to do it in cases where they either think, A, there's a lot of political support for it, or B, they think there's a really important constitutional principle to be vindicated that they believe must be upheld, as I think was true with Brown versus Board of Education. I do not believe, I could be wrong, but I do not believe there's a 5-justice majority that thinks there's a principle here that's worth going through this kind of pain. And to the extent that justices are influenced by these kinds of practical difficulties, especially, by the way, in the middle of an election, right? With the 2020 election, if you think of Roberts as somebody who doesn't want the court to be a major football in the middle of an election, the court trying to oversee this transition process in the middle of the 2020 election is another kind of thing that I suspect that's not the sort of thing that Roberts wants to see playing out on TV every day if it happens during the election. Like I said before, I think they could well just get rid of this on standard doctrinal grounds and not even think about these political considerations. But if in Roberts' mind or other justices' mind this is a close call doctrinally, it could be that their mind would be tipped against the O'Connor position or the DOJ position based on the practical difficulties like that.
15, 20 years, they could work it out.
Yeah, so desegregation ultimately took 15, 20 years, yes. This might be a bit, probably would be less complicated, but it would be far from trivial.
Yeah, I don't disagree on the Robert's perspective. I do think Ilya overstates the impact on the market because it will not affect the group market, the self-insured market, the ERISA. It won't affect Medicare, Medicaid. So it will be a sliver of the market. And what you're doing is restoring the ability of insurance companies to do experience rating and look at other factors, other insurance considerations. Justice Scalia never liked to have prospective overruling, but I think that here, if they wait till the next enrollment period, it's not anything like desegregation. I think that way overstates the complexity that would be involved. And I think there would be also state options. There's state law in some states. They would expand or establish or reaffirm guaranteed issue. So I think the practical problems, which are very real, and I agree with Ilya's perspective that the chief would not want to get the court in the middle of that. But I don't think that the guaranteed issue or the community rating is anywhere near the order of magnitude of anything, even the sentencing guidelines, certainly not desegregation or any of those big institutional reforms or the Apprendi cases. I mean, there's many cases where the court has gotten itself into a thicket and continues to have to deal with it. But this, I think, is actually a lot easier and not as big as the broader issues that would happen if everything went. I think that would be, I mean, because if everything goes, then you're talking about grant programs, you're talking about other kinds of benefits that people are getting as a result of their financial benefits. And I think that is a practical matter, even though I'm to the point where I think that may happen. I think that would be much more disruptive, and I think those considerations would be significant.
All right, we have time for...
Just on these two, I don't think it's as big a deal.
We have time for one final question. Robert?
Thank you. Thank you. Robert Bug, Librist Research in George Mason University. I'm going to throw out, my background is as an economist. I'm going to throw out one fact that might or might not be relevant and then ask a question.
We have no room for economists here. This is only law.
Well, okay, so I got a law connection too. No, now you got me not remembering my fact.
That's okay,
no, a couple of years ago when the individual mandate really was in effect and really did have a penalty connected with it, there were more people with exemptions to the penalty than paying the penalty. And if you add those two groups together, that was more people than were buying insurance on the individual market. So you really had the question of the effectiveness of the mandate, if it's legally relevant, it certainly doesn't look like it's economically relevant. Now, my question is, the economic logic tying guaranteed issue and community rating to the individual mandate is that if you have guaranteed issue and community rating, which we like to have because we like it, the market will fall apart in this adverse selection cycle with premiums going up if you don't get everyone in. And the idea was the individual market mandate was supposed to get everyone in. If I understood the logic of the original claim of unconstitutionality, it was the individual mandate was unconstitutional because nothing in the Constitution gives Congress the authority to make people buy health insurance and pay a penalty if they don't. If that's gone away, then if they decided that that's instead constitutional because it's a tax, and the tax goes away, how does that make it unconstitutional? Those three provisions were tied together by economic logic, but not necessarily by constitutional logic. Yeah. So if you want to pass something that has no individual mandate and guaranteed issue and community rating, it's stupid. It's not going to work. But the simple fact that you got rid of the tax or penalty I don't see how that makes it unconstitutional.
So there's really two issues here. One is the argument on severability is not that the rest becomes unconstitutional, but rather that the rest becomes something that Congress wouldn't have enacted, but for the part that is unconstitutional, and therefore the rest has to go. even though Congress.
But now they have enacted it.
So, yes. So that's the debate, right? The debate is that what is it exactly that they did in 2017? And my view, I think, is similar to yours. That what they did in 2017 is that they've created a system where you have guaranteed issue and community rating, but you no longer have a mandate with any real effectiveness. Your first point goes to the question of, well, maybe the mandate, even with the $695 penalty, wasn't all that effective. I think that's true. I don't think that necessarily means that it wouldn't be considered essential if we had had the same litigation in 2010 or 2012, because there you did have pretty strong evidence that Congress at the time thought it was essential, even if they turn out to be wrong. On the other hand, the fact that the mandate turned out to be relatively ineffective at increasing enrollment between 2010 and 2017 is relevant perhaps to understanding Congress's intent in 2017, in that it strengthens the case, at least at the margin, for the idea that Congress was willing to say, like, let's roll the dice on what happens if we have the rest of the ACA left in place, but a mandate that's largely neutered, maybe not completely neutered, but 99% neutered, whatever you want to call it. That, as it turns out, the expectations in 2010 were probably wrong, A, because the penalty was too small to really bring in a lot of people, and B, because even that small penalty, as a practical matter, often wasn't enforced against the people who didn't obey the law. Even under the Obama administration, the IRS wasn't all that aggressive at ferreting out these people and making them pay their fines or whatever. So from the standpoint of somebody who thought that buying Obamacare exchange insurance was too expensive or too unpleasant or whatever, they could make a calculation. There's not that much chance that I will be caught, and if I am caught, I'll only have to pay $695 plus some interest, and that's a lot less than I'd have to pay if I actually bought one of these insurance plans.
We can go down a lot of rabbit holes, and we've been down there, and we may be down there again. There was a lot of divergence between the functional aspects of the ACA and the political deal that first got it passed, as opposed to what it became later. In any case, Jim was quoting Yogi Berra before, and I would say it's not over till it's over, and then it takes a little while longer in this area of law. But thank you very much for staying with us thus far, and thank our panelists.
Thank you.
Thank you.